To record here, folks.
Bad, we didn't have it at the same time, right? Oh, no.
You're the boss.
Okay, good morning, everyone. We're getting started. Welcome to RAC meeting number 5 for the water right transaction rulemaking. And I believe everyone here has been here probably many times before, is familiar with logistics. Restrooms that way, elevator that way, and refreshments there. So turning it over to Laura for our agenda.
Good morning. So just a quick look at, it's same old, right? So we're gonna do some housekeeping items. We're gonna step through some rules. And then we're gonna do public comment and wrap up. So first, just a couple of notes about deadlines and materials. We've already received the meeting summary for RAC 1. I didn't hear any input or corrections on that, so I guess we'll go ahead and finalize that and get that reflected as final on the website. The draft version's already on the website, but we'll finalize that. RAC 2 meeting summary, I emailed those out and we've got copies in the back. And we'd like any corrections by the 23rd, which is day after tomorrow. So that we can go ahead and finalize those and reflect those as final. We are working on the RAC 3 and 4 summaries. We're close, but if you've taken a look at the summaries, you'll see that we're trying to format them in such a way that we're tracking the input and sort of the next steps. So it takes a little bit more time than just sort of dumping a transcription into the summary. So that's why we're still working on those. Mindy, did you want to give folks the lunch survey reminder?
People, we're still assessing that, so no.
So no, the survey for the RAC members?
Or did you already send it out?
I sent an email to get an RSVP head count for those in person next week. I need to know who's going to be in person for the morning or for the afternoon. If you have not responded to that survey, I believe the deadline is today or tomorrow, close of business, sometime soon. Please check your emails for me and respond.
Just tell you.
No, I need all the data in one place, please, because we have so many people coming.
Oh,
So many people on the list. I need it on all one place so I can download it all to one sheet, please, and thank you.
Jeff, can't you just give your assistant?
yeah, all right, assistant, get that done.
And then, just to review our schedule, particularly when we're looking for input, because I think there's been a little bit of confusion because of all the deadlines coming up. So, from last week's 2 meetings, we'd like, input on those divisions. So 310, 18, 315, and 17 by, the end of October, so 10/31. We started 380, we covered 2 rules. We're gonna hopefully get through the rest of it today. And so we'd like input on 380 by the 5th of November. Also today, if we do get all the way through 380, we're gonna start on 382. And wrap that up next week. Next week, we're gonna dive into Division 77. We're still finalizing those draft rules. I believe those are close and should be going out probably this evening or tomorrow. I'm looking to Raquel on Division 77 before the end of the week, something.
It'll definitely be out by the end of the week.
Okay. And then we're also gonna start talking about the statements of need, racial equity, impacts and fiscal and economic impacts. Those are pieces that go into the notice of proposed rulemaking. We'll be particularly looking to the RAC for input on the fiscal and economic piece there. And then October 31st, we have our virtual Division 2 follow-up meeting, 10 a.m. to noon. I sent a separate Outlook invite on that, and it's also in that very lengthy email you all got with the various deadlines and materials attached. And then the November meetings, I'm sure we'll have some more follow-up on those statements, as well as some probably rollover, perhaps from Division 77, and some returning to prior issues that, folks still had questions or concerns about. I don't know. Anything to add there?
Just a couple items. So for Division 2, that's that subgroup, so you don't all have to go. You're welcome to send your attorneys. I know some of you would like to do that, so feel free to do that. We're gonna be digging into the nitty-gritty of discovery and hearing schedules, so it'll be a super interesting conversation, right? That's more legal based. So, I am going to encourage folks for Division 2 that are attending that subgroup meeting to, bring your feedback and also bring solutions, right? The problem we're trying to solve is we're trying to make these hearings move through the process timely, right? We want to make sure we're providing due process, but we also want to make sure that we're providing timely decisions. And so the current process is not doing that. So if you don't like what's currently proposed, please bring solutions. That's really what we're here to do, is solve some problems. So I'm just gonna do another plug for feedback plus solutions. So we'll have that conversation on Division 2. One thing we should make a note, Laura, for our every meeting reminders is, so for those of you in the room, if you have something you'd like to say, you put your little tag up this way, and I think they're all cardboard-ish, so you can actually have them stand, right? And then when we call on you, you can put it down. If you're online, you can raise your hand if you're a RAC member. And for folks that are from the public, you can observe until the public comment portion of the meeting, but we won't be calling on you until that portion of the meeting. For everybody that's online, just a reminder that the chat is only for logistics, and so it's really just monitored here by our staff that are helping us on the logistics side, and it's not for a conversation about the substance. So on the substance side, please raise your hand so that way the whole group can see it. As a reminder, folks in the room cannot see the chat. So we'll have to make a note that we remind folks of this. This is being recorded. And so I'll just note that as a reminder as well. Back to you, co-captain.
Okay, thanks so much, Raquel. So as a reminder for folks and for anyone who hasn't met me yet, who is joining us today, Katie Ratcliffe, I'm the Water Rights Services Division Administrator. And to my left here, Lisa Jaramillo, the Section Manager for Transfer and Conservation Section. Obviously a critical part of all of our discussions about Division 380. So we also have some of our subject matter experts online. We will call on them if we need to. I wanted to also ask, we're just talking about the cards to indicate that you have a question or the raise hand feature online. So I'm gonna pause after I get through a rule section or group of sections and then look for questions. So just because I don't notice your hand right away doesn't mean that I won't get to it, but that'll allow me to move more efficiently through the discussion. We've got a lot of pages to cover here, but excited to receive folks' input. And then, so going back to a high level overview, some of this is gonna start to look familiar to y'all based on previous RAC meeting discussions, the draft rules that you've been looking at for other divisions. You're gonna start seeing some of the same language that is based on implementation of House Bill 3342, which is the Water Right Transaction Streamlining Bill, and House Bill 3544, the Contested Case Streamlining Bill. You'll see that reflected here in Division 380. So there is base processing, like we discussed for new water right applications, but there's some nuances. So we'll talk about that when we get there. And that's not discretionary, but it's strictly implementation of the House bill. There's electronic notification. We have updates to our terminology. As I mentioned last time, draft preliminary determinations or DPDs are now being called initial reviews. Thank you for your flexibility there. Thank you, tax. And then preliminary determinations are now being called proposed final orders. Final orders magically get to stay final orders, so that's nice and simple. But for folks who are really used to going through the transfers process, I wanted you to understand the terminology that we're using. It's been made consistent now. There's also updates based on House Bill 3544. So protests of proposed final orders and contested case proceedings are governed by House Bill 3544 and Division 2. There's also the default to final order process prescribed by House Bill 3544. So if somebody doesn't protest and we get 30 days past the close of the protest period, the proposed final order becomes by default a final order. So that does drive some of the structure of our rules, and some of the red line is really based on addressing that. So I won't highlight every single one of those changes as we come to it. If you have questions, feel free to ask, but for the sake of time, I won't mention every one of those strictly implementation items. And then we also previewed last week some of the items that are specific to the transfers process that we think will be of most interest to the RAC. So please hold comments or questions on those until we get to the applicable section. Okay, diving in. So the first three, I think we can cover quite briefly, starting with purpose at 0010, that's on page 1. And then I'm going to batch that with applicability on page 2 and definitions on page 3. So those are fairly straightforward. We have some rule cleanup, rule reference updates, and then in the definition section, we have the removal of a reference to a standing statement because that no longer applies based on House Bill 3544. And we've moved some definitions out of 380 into 300 because they're definitions that we thought were appropriate to include in that particular location. So water use subject to transfer is now based on the statutory definition, but that is in Division 300 as we noted when we were in Division 300 in this RAC.
Sorry, is 300 an umbrella over 380?
It does apply to 380.
Yeah, okay.
Yes, good question. Okay, any questions about those groupings before I move to the next part? Okay. So the next one we're moving to is 2110. And that is change in point of diversion or point of appropriation. So we'll go to page 5. And here we've got some rule cleanup and consistency changes that are fairly basic. But what I did want to draw folks' attention to is an explicit statement under sub 3 to reflect that we may condition a transfer to protect against the potential for injury or enlargement that may occur as a result of the change. So we, for transfers, look at whether there would be injury or enlargement, and we also have authority to condition to protect against injury or enlargement. And in some cases, that may lead to a more favorable outcome for the transfer. So Glenn.
I was just wondering if that is more explicit than the law why do you feel we need an explanation there versus just going back to the underlying law?
I think we look at where folks get confused sometimes, or where there's argument, where we believe the authority is really clear. But somehow, it just leads to confusion for folks. We decided to make it really explicit to reduce the potential for confusion. Is there anything you want to add?
And it's our current practice that we apply those standards to transfers. And so just making it totally transparent and clear, this is our process, and we believe that the statute gives us that authority.
So similar to, thank you, to new water right applications, we look at a separate set of criteria. There's some overlap there, but not entirely. And then if we have a way to condition a water right in a way that's reasonable, right? It needs to be something we can actually, there's some conditions that wouldn't be reasonable, but there's a lot of cases where we can condition an application in a way that does lead to a positive outcome. And so we do that. And same thing for transfers. Jeff, you have a question? And I'll go to Austin.
This got flagged by our legal counsel. I get the fact that you're saying that it's already your practice. But, our argument has been that injury and enlargement applies only when the department is reviewing the transfer, not the future after the transfer is approved. So, I mean, it gets kind of to my friend down the table from me about the explicitness of this. And so that causes a question of, do you believe this is under your existing authority? I mean, there's one thing in practice what you've been doing, but as we touch these water transfer issues,
Yeah.
I'm just signaling that we're probably far more sensitive on this part of the rulemaking than any other part.
Understandable.
Jeff, you said something about future. Can you restate that just for a second? Because I'm not sure I was
See,
tracking.
the only thing I can do is read. And so I can ask Marika to follow up on
Okay.
that, but I get her general point that when we read that in terms of its raw language, it seems like you are presumptive. It's just not when you do a transfer, when it's evaluated, you look at injury and enlargement.
Yeah.
But in advance to condition it to have those things. It seemed like it needs to be cleaner.
Yeah, so I think it's probably, so
Yes,
what
it is the word potential.
Yes.
I'm hearing is that, well, so one, it's the word potential, but two, it's not an objection to enlargement. It's an objection to the conditioning portion of it and this potential word. So we might want to think through, because so sometimes, for example, we'll put on there, Lisa, tell me if I'm going out in the wrong direction, okay? We will require water use measurement, right, for example. And that will, because you can't take more water at the new location than you could get at the old location, right? So for example, you might have to measure. If you put that, if you do that condition, there will be no enlargement. If you don't do that condition, there's likely to be enlargement. That's the potential part.
Yeah,
Right?
I push back.
There could be, okay, let's just say, but let's say this is a definitive situation where there would be, okay?
Oh,
So,
that's proof that you're, okay.
so my point being is if you have the condition, right, then there is no enlargement. If you don't have the condition, then there is enlargement in that particular situation. Now let's go to the situation that you're talking about, which is like, well, okay, maybe there would be, maybe there wouldn't be, right? Well, how are we supposed to guarantee that there won't be?
Oh, my goodness,
If-
but, I respectfully, I think when you make your transfer request, you have to prove up that you're not enlarging it or injury, right? That, especially if you're not enlarging it. So when we have as a practice and we want to transfer something, our members know that you only have so much.
Yeah.
And so maybe it's just the framing of it that it assumes the bad intent that you're going to try to enlarge.
I don't think there's an intent
Yeah.
here. There's just us trying to manage.
I
on the
just don't see the
ground,
reason
right?
then for the conditioning.
Well, we
Because it's
have-
part of the
we-
approval process.
Yeah, like Raquel said, we have to do what we can to ensure there's not gonna be any enlargement. So we're putting sideboards on the approval just to ensure there won't be. And so like, it's the same as, if there's a place of use change, we put a condition in the order that says the lands from which the water right is moved shall no longer receive water from that right.
Okay, I
So
mean,
that's a condition we put in there to ensure that everybody knows this is what has to happen, so there won't be.
and
enlargement.
not to draw this out, I'm seriously not trying to filibuster here. Maybe because it's fresh in my mind that I was talking with, the consultant yesterday about how to have this process be more efficient. So in my view, subject to changes in my legal counsel's point of view, I'd rather have that be part of a checklist, that when you're doing your work as to do a transfer, making sure that there's a box that you're not enlarging, you're right. I mean, that's not putting it into the rules that for something that might be potential.
So
I guess I'm digging in harder on this for reasons that pass even my own understanding.
I would just add that, so enlargement is one thing, but if enlargement is occurring, it
should be
may
denied.
cause injury. And so we're looking out for other water rights that may be injured as a result of the transfer. And sometimes enlargement can cause injury, not always.
Okay.
So, I see what you're getting at and we'll think on it a little bit more. I think that the checklist part is that this is, through our process, we usually say we can approve this transfer. We will find that it doesn't cause injury or enlargement if it has these conditions. If it doesn't have those conditions, we may not be able to find that it doesn't cause injury and enlargement. And then that would be a denial, right? And so that's kind of the just maybe switching how we think about it a little bit, is that conditions are often included so that we can approve it, right?
Yeah, so for some reason I'm reading it in the negative.
I hear, and that's why I was like, it's not intent, right? We don't think there's any malintent here. This is just, how we assure that we can meet the threshold of the statute of finding it, right? So we can think, oh, there's all these names tags going up now. Okay.
Sorry.
Yeah.
Sorry,
There's so many hands, sorry.
Yeah, so I'll try and gauge order. I'm not entirely sure, but I do know Austin was next.
Left to right is
Left
the
to right.
order that the hands were raised.
Oh, hey, learn new thing. Okay, thank you, Wendy. So we'll go to Austin next.
Hey, good morning. Austin Patch with Summit Water Resources. I did also want to touch in on the enlargement conversation that we're having. I've read Division 380 and there's a bunch of inclusion of enlargement that wasn't previously in rule. And so, I wanted to check back on chapter 540 and, injury is very well documented in the statute, but enlargement isn't. And so there's multiple sections, including this one, where enlargement isn't explicitly stated, as a criteria. So, you were kind of leaning into the answer of it's by practice from the department to consider enlargement. So I'm curious if, it presents a problem when enlargement isn't explicitly stated in statute, and how that kind of rolls out into the rulemaking.
Yeah, thank you, Austin. I appreciate that. So yes, one of the elements is that we look at injury or enlargement when we evaluate transfers. So explicitly stating that in the rules is intended to help everybody understand how the process works. But in addition to that, so we go back to the fundamentals of water law, doctrine of prior appropriation. And so in times of water scarcity, I know most of the folks know this, but I think it's worth revisiting. In times of water scarcity, senior users are entitled to receive water before the junior users are. The junior users may be regulated off in favor of the senior users getting their rights. And so folks come in, they get a priority date once they get a water right permit, and they get it for a certain amount. They get it under certain terms and conditions. And so we cannot then, through the transfer process, allow somebody to enlarge their right while maintaining their senior priority date at the expense of everybody else. So this is really one of those water law 101 fundamentals that we have been practicing in accordance with the doctrine of prior appropriation, but we're making it explicit for folks. So I appreciate that question.
So is it, sorry to just go on here. So is it the basis that enlargement will cause injury? And is that why enlargement is rolled over to these rules?
So it could, that's one reason, and Lisa can explain that further, but it's also enlargement on its own is against the doctrine of prior appropriation. So that's why it's important as its own criteria, whether or not it could lead to injury.
And just because there's, there could be enlargement, doesn't necessarily mean there could also be injury, but they can go hand in hand, but not always. Yeah, if we allow a transfer and someone chooses to somehow enlarge use as a result of that transfer, then we're essentially allowing somebody to gain new water without going through the allocation process of getting a new permit.
Thank you.
Thank you, Austin. And so apologies, I don't know, Glenn, if you were next or if James was. Okay, James, we'll go to you next. Thanks, Glenn.
Good morning, everyone. James Fraser with Trout Unlimited. I have two questions about page 7, subsection 2C. You'll scroll up a couple pages. Yeah, you've got it there.
I don't think we're quite there yet. So James, could you hold that comment till we get to 2120?
Okay. I thought since we went down to page 9 that we'd already passed this up, but I can wait if you're not ready to go to this content yet.
So I think where we're at right now is page 6. If you look at subsection 3, that's what a lot of the comments are on. So we will then turn to 2120 and I'll be looking.
Oh, gotcha. Okay, thanks.
Yeah, thank you. Okay, and then I think we have Glenn and then Chris.
I'm wondering on back to potential. I mean, that word, when it's so unknown out there, and I'm wondering if likely is a better term for that.
Oh, okay.
And then how it really reflects to the underlying statutes on, just going through that, what proving injury.
Yeah.
I do have another comment on enlargement when we get to in-stream water rights, so I'll hold that comment until then.
Okay, great. Thank you, Glenn.
Good job,
Okay. Oh, go ahead.
Yeah, so we'll take a look at that. That's helpful. This is helpful. So, and again, it's not about intent. So, but that is very helpful and we'll take a look at that. And I hear it in the room. So we'll come back and make sure that we revisit this conversation, I think.
Thank you. So Chris, please go ahead.
Good morning. So I have one question, and if I was sleeping during this part, I must apologize. But can you explain one or two examples of what conditioning a transfer to protect against the potential for injury or enlargement would look like? When I think of conditioning water rights, I think of decline conditions, which we know are roundly ignored once they're set. And I definitely think that all of these rules should be prospective, looking forward to address preventing harm in the future. And I understand that you can't always know exactly right now what's going to happen, but if you could share with me that information, that would be great. Thanks.
Yeah, a simple condition would be for enlargement that could also point to injury is you're only entitled to the amount of water that's lawfully available at the original point of diversion. So if you're changing to a new point of diversion downstream, you can only take what is available at the original upstream POD. So that's one.
Okay. You're not talking about 5 years after approving the water right transfer, all of a sudden condition has been tripped and now we need to dial something back?
No, it'll be it's a condition that we come up with at the time of approval that would allow us to approve, and then it stays in place. So like that is just dependent upon stream flow. And, I mentioned earlier, if it's a place of use change, we, make the person dry up the from lands, so you can't have any more acreage than you did. I had another one and it put it away.
So we're getting to,
definition.
we're
Yeah.
getting to my point then. There really is no controversy here. The reason why I'm asking these questions is because obviously you have to draw up the place of use. That's a condition of getting the transfer. So I just want to make sure that we're not conflating the concept of a condition such as a decline condition on a water right, which means, yeah, we'll give you this water right where we don't think there's water available, or we don't know if water is available. And then if it declines by 25 feet, you need to shut your well down, right? That's a condition out in the future, but that's not what you're talking about. And I just want to make sure it's clear what you're talking about, as you described, is we'll consider this transfer, but yes, there are conditions in order to make the transfer work. That includes obviously drawing up your place of use. That means putting in fish screens or some other things. Am I understanding this better now?
Yeah, with the wells where they have the decline levels, when we're evaluating a transfer, we will, if those decline levels have not been triggered, then we can move forward. Those conditions will carry forward with the transfer to the new well. If they have been triggered, then we would, and they're not likely to recover, then we would likely deny the well location change, because to allow it would be, it's enlargement. If it's supposed to be shut off here at the original well and we allow somebody to move to a new well, they shouldn't, it's, to do otherwise would be to allow it and then tell them, okay, we're allowing it, but you can't use it until the static water levels recover.
Yes, and I was only using the decline conditions as an analogy where there is something in the future that might get triggered, and that's a condition. And this is not what you're talking about here. You're not talking about approving water right transfers with conditions that could potentially get triggered some 5, 10, 15 years in the future. You're simply talking about conditioning them in order to process them in the present moment.
Chris, that is somewhat true, right? If you have a condition on your permit already, right, that is some instance in the future that will get carried over, right, onto your new permit.
Sure,
right?
of course.
And so if, for example, you have a condition on your, we'll use surface water because surface water is always easier. If you have a condition that says you can't use more water than what is allowed at your, or available at your old POD, and in the next 9 years, there's the same amount of water or available at your old POD, right, is downstream. And then at your new POD, and then in year 10, there's a really severe drought and your old POD drops, let's say, we'll just say 0, because 0 is easier than trying to do math, right? So down to 0 CFS, well, but there's water available at your downstream POD. That would be an instance where you can't take water at your new POD, even though it's 10 years down the road. The condition's always been there, right? The requirement to monitor has always been there, but because of drought conditions, all of a sudden you actually have to shut off. Does that make sense? So it's
Yeah.
kind of a yes, but it's kind of a no also.
Sure, and I'll stop after this, but I just want to make it clear that you're not talking about approving a water right and then 5 or 10 years later somebody claims they're injured because you didn't do your contested case right, or you didn't do whatever, or your protest didn't work, and this water right transfer would not be conditioned against the potential for injury in the future. So I just want to make sure that's clear, that if somebody
Yeah,
claims
Chris,
they're
that is
injured.
correct. That, what you just said, that is correct.
Yeah.
The only exception to that would be if we're talking about in-stream leases or temporary transfers, right? Which have a condition in them that says if
Mhm.
injury is because they get a faster and less rigorous look, right? We have the ability, if we find injury in the middle of that lease or temporary transfer, we can shut off. But so when we're talking about permanent ones though, there's not generally that kind of a condition, correct?
Right,
Yeah.
right.
So
Yeah.
yes, you are correct on that front.
So in
With the
general,
lease-
I just see no problem with this provision. Thank you.
I think you just said that.
On. Yeah, I mean,
Okay, Kimberly, please go ahead.
Yeah, first of all, I just want to let Jeff know that I don't have much bandwidth, so I'm probably not going to be on my video much. But I just wanted to say, just add on to what, or just respond to what Raquel said, which is, she's hearing in the room that there are a lot of concerns with this. So I just wanted to provide a counter that Water Watch strongly supports this. And I think, I think the Water Resources Department has done a very good job in explaining why it's in there. But just one thing to add is that, and this, hopefully, Jeff, this will help, but this is only related to conditions to ensure against injury and enlargement. It's not a larger standard. So in other words, they're not suggesting that they can put in conditions to protect the public interest at large. And I'm only mentioning this distinction because I think this is a nuance that has come up in some of the transfer conversations. So I just want to highlight that, again, this is just to protect against injury and enlargement. And just to drive home one point that was made by Raquel is without some of these conditions, the department would have to deny these. So oftentimes they are very helpful to the water users in our perspective. That's it. Thank you.
Thank you, Kimberly. All right, we've got Carrie and then Lauren.
Hi, Carrie with the Confederated Tribes of Grand Ronde. I just wanted to note that it sounds like from OWRD's perspective, what I understood you were trying to do is, so DEQ has done this in another permit that I'm very familiar with, which is the National Pollutant Discharge Elimination System Permits, NPDS, where they include conditions and that are necessary for the permittee to be in a certain construct. And then they put a legal statement that says, as long as the permittee abides by these conditions, we've determined that they're in compliance. So I think that's what you're saying is we add these conditions to ensure against injury and enlargement. So there may be other ways to write what you've written that are more clear to the folks who have concern about the language.
Thank you, Carrie. Lauren.
I just had a quick language suggestion. If the issue is the potential for, if the sentence reads fine, if you just take that out and it just says to protect against injury or enlargement.
Yeah, agreed.
So it takes out that speculative word that.
Okay, thank you. All right, well, thank you everyone for that discussion. I think that was great that that
Like
occurred.
25 minutes ago.
Sorry.
I think it was good we talked about that up front because as often points out, we're gonna see that appear throughout the rules. So now I don't necessarily need to bring it up every single time we have it in here. It is in our rule summary though, so if you all want to look for where it appears, that's an easy way to find it. So moving to, so James, queuing you up, moving to section 2120, and that is on page 7. So we've got, there's a number of changes, but I'm gonna highlight the ones I think of most interest. So categorically here we have process improvements, we have efficiencies, some policy and modernization elements, rule clarity, references to our mapping standards and policy and procedural alignment. So I'm going to call your attention to some of these items here. And so, the first part is under sub 2, sub C. And, here, we need information for, so actually I didn't, list off the name of this rule section. So this is change in point of diversion or appropriation to reflect historical use. And so an applicant for one of these changes needs to include evidence that there's been no claim of injury. We've added some information I'll get to, prior to the request for the change in the point of diversion or appropriation. So you're gonna see kind of two categories of changes in sub 2, sub C. And so the first one is just being really explicit that in-stream water rights are water rights. They can be injured. And so we have the reference to in-stream water rights under 537.336. So that is state agency in-stream water rights. And then in-stream water rights created pursuant to ORS 537.346. So that's minimum perennial stream flows that have been converted to in-stream water rights. Again, those are water rights. They have the potential for injury. And so the second category is validated by the local water master. So here we wanted to make it really clear for folks that it's not enough for someone to make a claim of injury. For example, a neighbor is frustrated with a neighbor and they make a claim that there's been injury. That's not enough to make it a problem. The claim needs to be validated by the local water master. And so that's why we have validated by the local water master. And you get a bit further down in sub C, that no validated, we've added the word validated, complaint of injury has been made. So those are the two categories. James, I know you first wanted to talk about this, and then I'm going to go to Jeff.
Thank you. Yeah, so that's helpful background and exactly the language. I have two comments or questions about this subsection 2C. The first is that the cross references to in-stream water rights statutes seem to be missing a couple, and I would suggest just leaving it as including to any in-stream water right. For instance, there's no reference to 537.348, and there's no reference to 537.465. So if you're going to have cross references, that list appears to be materially incomplete and at risk of leaving things out. I think you have the same value and it's shorter if you just leave it as in-stream water right.
Thank you. We'll take a look at that. Appreciate it.
And
Jeff.
then
Sorry, go ahead. I apologize.
that's okay. The second comment or question is about that validated language. This stuck out to me. It's the only place in the rule package where you have that word validated. And I think at least the first instance of it is unnecessary and actually pretty confusing. You know, if you're looking at whether there is a validated claim of injury, the second instance is, I think, all you need, because it seems to be two different validated claims, or is it the evidence that's validated? It's hard to read and understand, and I think you get at it by just the second version. It does seem to maybe add a process step to all this where, you know, the rule now requires some finding by the water master of the validity, and that's documented somewhere. That I don't have any issue with that necessarily, but I think you should probably drop the first new clause. Thanks.
Thank you, James. So I'll ask Lisa, that is part of our current process, right? That the water master weighs in on if it's a validated claim.
Yeah, we've had instances where folks are upset because we accepted a historic POD or POA change because they've complained to the water master about this and they didn't do anything about it. And why are you accepting this? Well, it's because it wasn't injury. And so that's what we were trying to just clarify there for folks, you know, that it's to be a claim of injury, it has to meet the definition of injury.
So we'll take a look at the phrasing there, James, and make sure that it's clear.
That makes sense. I think you get all of that value and detail by just having the second instance that says no validated claim of injury. If it's in there twice, it seems to mean there's two different things that need to be validated.
Okay.
Thanks.
Thank you. Appreciate
You
it.
want to call on Arla? Since she's sad. I have something to add.
Sure.
Okay, we're gonna hold on. Jeff, go ahead.
Yeah, I actually like the validated one, just, we're not to be a counterpoint, but the question I had was in C, the mention of in-stream water right at all. Doesn't that standard already apply to all junior and senior water right holders, either in-stream or consumptive already?
Yes.
I get that you want to call it out, but as we're doing these, where it's necessary, where it may not be necessary is my only point there.
Yeah, Jeff, I think that's a good point. And so, I think it's just looking for opportunities where people tend to be confused. And as part of streamlining, just trying to make things as clear as possible in the rules. So when people say, why are you doing this? We can just show them the rules. So where there are those areas where people get confused, we are trying to add some additional language. Is there anything you wanted to add there? And this was also, I'll just, for full transparency, this was a request made by our state agency partners. So I think that they were seeing that maybe folks weren't clear about this. I understand your point though. Yeah, understanding. So I think we've got, oh yes, I learned, we go left to right on the hands for who was first. So Greg, please go ahead.
Yes, good morning. Greg Capillas here, representing Oregon Groundwater Association. I don't know, I'm kind of trying to wrap my head around this whole concept of a claim of injury for an in-stream water right. I mean, how's that done? Who submits claims of injury for in-stream water rights? How does that work exactly?
So, it's in the statute that's a criteria. There can't be any claims of injury against the historic point of diversion or point of appropriation. And so that is, it's typically someone out in the user community would contact the water master and say, hey, this is happening. They're using this different point of diversion and it's injuring me. So
Lisa, I think that the question was getting at for in-stream.
oh,
So, Greg, the water master, right, for example, I think in this case is if they've noted that this historical POD change is injuring an in-stream water right, that would be an example, right? Does that make sense?
But the water master would have had to have noted that prior to the
Correct,
the application.
correct.
So I'm just kind of wondering, is it, oh, I'm sorry, go ahead.
It may very well may be, so let's give a very clear example. The water master may have ordered them to shut off, right? Because they're saying you're injuring this in-stream water right. With this, historical POD change, you can't then go and use this process to get that legal, right?
I see. Yeah, okay. And I'm just kind of wondering, would it be possible, for example, for somebody to move a point of diversion upstream and then use it for many, many years when, then when such a move might actually be, causing injury to an in-stream water right? Right? I mean, that's a situation where we know, well, we generally don't even think about doing point of diversion changes upstream because that usually opens up this whole can of worms of, injury to in-stream water rights. But if somebody were to do that sort of unknowingly, move their point of diversion upstream and use it for what is the time limit? I forget, it's the number of years, 10 years, something like that. And then decide that they want to go ahead and apply to document that change. If there had been no claims of injury to those in-stream water rights during that period, would they be allowed then to do that transfer?
So Greg, the statute says that the claim of injury must be documented prior to,
Yeah,
right?
To
right.
qualify to apply.
Yeah, to apply.
And then we also will be consulting with the water master as part of the evaluation. And so, if we see an upstream POD change into an in-stream water right, reach, then that's probably gonna be a flag that we can't allow this.
So Greg, that gets at, this is, so Lisa's point was that that is to apply, what everyone is reading that, you know, 2C. But when you get into later on in the rule, under 5, it says that the change does not cause injury or enlargement, right? So, so there's that standard over there. So to apply, you can't have this history, but there's also then that separate finding.
Well, okay, so it sounds like what you're saying is even if you've made a historical point of diversion change upstream into an in-stream water right, and there have been no claims of injury made to the water master is not able to validate any claims of injury, that transfer still would not be allowed because it would cause injury to that in-stream water right. Is that what you're saying?
That's what I would expect to see. So there's
Okay.
the first hurdle is to qualify. So, and then we do a water master evaluation, like any other transfer. And so if things like that are flagged, then we need to address it.
So think of the first part as application requirements, and then the second part is our evaluation.
Yeah.
Okay, all right. Thank you.
Thank you, Greg. All right, I'm not sure if we had Kimberly next or Glenn.
Kimberly.
Okay, thanks, Glenn. Kimberly, please go ahead.
Yeah, just to the, to the extent that one of the purposes of this overall omnibus rulemaking is to align sections of rule that are inconsistent with statute, is to change them so they're consistent. I just want to say that we have some pretty serious concerns with this section of rule. And to the extent you are now expanding it to clearly put or appropriation into the title, that sort of flagged it. If you look at the statute, which is 540-532, it is directed only at points of diversion, so stream flow. And I know, at times in history, the department has said, well, we use the word the statute use the word diversion to mean both appropriation and diversion. But in this case, if you read the statute in whole, it's very clear that it's limited to diversion, because anyone who, for example, anyone who comes in and asks for this or requests this, it automatically goes to ODF&W for review on fish screens. So I don't think there's any argument that this did apply to appropriations. And so our request is that this section be reworked in whole so that it only applies to historical changes in point of diversion.
Thanks, Kimberly. Yeah, we'll take a look at that. So the language was added to reflect our existing practice of processing historical POA changes. I understand your point that you're making though, because yes, statute only talks about POD. And my understanding is that our long-standing practice in transfers is that when we say POD, that unless the context shows otherwise, it could be POD or POA. It's basically where you're pulling the water from. Do I have that right?
Yeah, generally, the transfer statutes talk about points of diversion, period. So we apply that to both surface water PODs and groundwater points of appropriation. And then just to note that the rule already has the language about change in point of diversion or appropriation in the text. We were just clearing that up in the heading.
Yeah.
Yeah. Oh, sorry. Yeah, I know it's already in the text, and I guess our ask is that it be taken out. And to your point on the appropriation versus diversion, again, in this particular section, it's very clear it was aimed only at point of appropriation. And just so folks in, on the RAC understand our concern is that with groundwater reviews, with groundwater permits, the groundwater reviews are based on well location. So if someone is using it in a different location, there are impacts, for example, impacts to stream flows that at the unauthorized point of diversion would not, or point of appropriation would not have been considered. So we've seen instances of concern with this, and so just wanted to note it today. And we'll be putting this in our written comments as well. Thanks.
Thank you. Thank you.
Okay, Glenn, please go ahead.
This might be crazy, but should we specify we're looking at existing water rights as injury when you're talking about in-stream water rights?
Glenn, I think you have a point there. When I was listening to the conversation, I'm wondering if we just need to put it in the definition of injury instead of sprinkling it here and there, right? So I think you have a point there because if we're gonna call out one, we should probably say existing water rights, including in-stream, water rights or something like that. But if that's really the concern is folks don't realize that in-stream water rights are existing water rights, right? And we're trying to address that. So I do think there's a point there for us to take a look at that.
And the other question I had is that you're talking about injury to in-stream water rights. Well, there is instances where in-stream water right can injure out-of-stream water rights. And I'm wondering if you want to spell that out as well.
So the 380 is for changes that are not in stream, correctly? Because Division 77, which I know everybody's excited to see, including me, I'm working on it right now. That's the one that talks about changes to in-stream where that would be applicable, where the in-stream would be. Since this is not a change to in-stream, that wouldn't apply in this rule.
Well,
right?
but you're spelling out that a point of diversion may cause a problem to in-stream and your sister agencies wanted to spell that out. But we can, as a application for in-stream can cause injury. So I was just wanting that's a two-way road there.
Yeah,
I want to clarify that.
Yeah.
I think that'll be in Division 77 on
Okay.
that part.
All right.
But yeah, and
Remind me.
Okay. But just to follow up on that, we do look at that as any other existing water right, including any existing in-stream water rights.
Christopher.
Yes, thank you. So just a point of clarification or a little more questioning here. I think there is an equivalence being put here that a historic use of a point of appropriation is equal to or similar to one of a point of a diversion. So say you move your pump upstream by 1,000 feet, right? And that's a change in the point of diversion that you kept for 10 years. And now you want to get it square with the books. But we know in a lot of places, especially in the Harney County, there are numerous instances that water users went and drilled a well that was not associated or approved with a water right. And then they went and started pumping from that well. And it's a misappropriation of water. And I understand the department's interests in bringing along these misappropriations of water and correcting them. And so, oh, well, you went and drilled a well 10 years ago. You didn't tell us. You've been pumping from it forever or for however long. And now we're going to put it on paper and we're going to bring it. We're going to make it lawful, essentially. I think that is a significantly larger harm or misappropriation of water than just moving your pump upstream a little bit. And so I don't think they're equal. And the idea that maybe somebody moved their well, drilled a new well and then pumped from it from a water right, and maybe it's within a quarter mile of a stream or any of that. So what happens is that I don't know that you could necessarily approve something that was as close to a stream as that. And in fact, actually, it would trigger shutting the well down. And it would also be evidence of the water masters technically not doing their job by not being aware of the fact that there are these wells that have been operating for years, misappropriating water too close to streams. And so these are just thoughts and ideas that are coming to my head as we're having this discussion, and I just wonder if they're relevant at all. Thanks so much.
Thanks, Chris. I would just add that when we do have historic groundwater point of appropriation changes, we do request a groundwater review from our hydrogeologists on that. So so they are taking a look at that historic POA location, and we would have to ensure it's the same source of water, same aquifer as well on those.
Thank you. Okay, well, thank you for a rigorous discussion on that one. The next one that I wanted to point out, still in section 2120, is found under, well, there's several changes related to this, but primarily under sub 4. And so there's a requirement under statute that the applicant send out notice to affected water right holders. But we've had the experience that in some cases, water right holders were not actually notified. And so to make sure that that occurs, we've added language requiring that the applicant send notice by certified mail with return receipt requested to all such holders, the water right holders that are affected. And then within 14 days of that, they need to provide us the signed and dated certified mail return receipt as proof of service upon those affected water right holders. So that's to make sure people get appropriate notice that their water rights that they have may be impacted. Okay. Any more questions on that section before we move forward? James.
Thank you. Just briefly, similar to my comment above in 2C, this list of in-stream water rights and the sections that they're created under in statute doesn't seem to be complete. And referencing the cross references again, it doesn't mention 537.348 or 537.465.
Okay, thank you.
Thanks.
Yeah.
This is very small and minor, but on that 5B, I think where you just were, there's an extra comma after May. I don't know why that's, maybe
Yep,
that's
there
just
is.
a typo. That's it.
That is, yeah. Thank you. Thank you. Carrie.
Just a question, logistics. I've been involved in situations where people refuse to accept certified mail. So what happens if that happens? How does the person address getting the proof of mailing that you require?
That's a good point. It might. Just thinking we would probably work with the water master to see if they could take it out or hand deliver it. At that point, that'd be a workaround, but maybe we need to help something out.
Yeah, I just can see in a contentious case where the person knows they can hold the process hostage by not cooperating.
Discussion. Glenn.
Are we to 5B as just the potential for injury comes back up again and just wanted to flag that?
Sure. Thank you. Okay, so moving into our next section, we've got 2130. Not a whole lot to say there. That's rule clarity and updates. Going to 2200, changes in place of use. That starts on page 12. And so here we also have some rule clarity to refer to Division 18, Division 77, because those are also situations where a change in the place of use may be made. So we want to make sure that list is comprehensive. But the change I really wanted to point out, and Lisa will turn this to you in a second, is making sure we've got language that supports the fact that following a transfer, the lands from which the water right is removed should not continue to receive water from the same source. So Lisa, I wanted to turn it to you to explain some of the changes we've made to assist with that.
And we're at 2200.
Yes, 2200 changes in place of use on page 12.
Yeah, and if you turn to section 2 at the top of page 13, we're just calling out that in order for us to consider and approve a change in place of use transfer, that the lands identified for the change must actually be moving to a new location. We can't pick it up, put it back down in the same spot. So we're only interested in those actual slivers, areas that are physically moving to a new location. And that, like Katie said, aligns with the definition of enlargement that we have to be able to affirm that the from lands in a transfer are being dried up. So the water rights being picked up, moved to a new location, and then that area where the water rights came from won't continue to receive water from the same source under that right.
Any more thoughts there, Glenn?
Yeah, I find it interesting because sometimes on these older pre-adjudicated rights, there's lands that were sub-irrigated naturally that has an overlying diversion tied to it.
Right.
And they may not have used that full right. And then they want to transfer it, say, to an in-stream. And yet that land is still being wet, is still wet because it's naturally wet. So is that an enlargement?
It would be, and typically when we're looking at in-stream transfers and leases, and same things with place of use transfers, if that from area is inundated with water, we won't allow them to move it as part of a transfer because that area is not benefiting from the irrigation. It's just naturally wet. So to allow somebody to pick that up and move it to a new location is actually enlargement because they were never truly irrigating that area. So we'll typically have people, you know, that is not going to move forward in the transfer or lease.
Great. Yeah, great. Go ahead.
Yeah, I just wanted to, I guess, mention that this subsection, this section 2 kind of is something that, you know, I don't know, maybe comes out of some recent discussions that we've had with the department, because of this type of transfer where you you know, what Lisa mentioned, you sort of pick up the whole thing and then you set it down in a slightly different footprint, but maybe a large portion of it is still covering the same ground. We've done those transfers for years, and the reason behind that is that it allows us to keep the whole water right together. We don't end up, you know, with multiple water rights, you know, with original permits. Yeah, you know, and then if down the road you want to go make changes to that same ground, you may end up having to deal with multiple water rights. It just kind of simplified things for our clients, we found. And I mean, I can't think of any reason why doing that, if you're just talking about the same acreage, you know, you're not changing the acreage, you're not enlarging the acreage. I can't see where in most of those circumstances there, you know, there'd be a concern for enlargement. That those are just, I mean, like, first of all, I guess I just kind of wanted to point out to the group for the benefit of the members of this committee that this is something that the department did allow for a number of years. Now they've kind of decided they don't want to do it anymore. You know, I don't really, I'm not sure I have any great additional arguments to make, except that, you know, we were doing it because it kept things simple, and there were no issues with enlargement. Those are my 2 cents. Thanks.
Thanks, Greg. Thank you, Greg. Appreciate it. Okay. I'm going to batch the next 2 sections together. So 2240, which is layered water rights and certificates of registration, starting on page 13. And then also 2250, transfer supplemental water right or permit. So in these 2 rule sections, we have some House Bill 3342 implementation for electronic documentation, rule clarity and updates. But a lot of what you're going to see in there in terms of changes is that we've added language to explain when and what information we provide to applicants to help them resolve layered water rights when possible. And do that as early in the process as possible. Any comments on those 2 sections?
Katie, I'll note that you have passed your time for a break.
I know. We are having fun. So the officially scheduled one is that 10:15?
We don't have an official one.
Oh, I get to choose.
Yeah,
How
you get to
wonderful is
choose.
that. Okay, we'll take a break at 10, so we'll keep going another 15 minutes and then we'll take a 15-minute break starting at 10. Thank you, Raquel. Okay, so moving quickly to exchanges of water. So that's section 2260, page 16. And so that is simply implementation of the 2 House bills we've been discussing, public notice, references to the protest process, and final orders and contested cases. So not a lot of additional information there besides implementation.
Those are all prescribed,
Yes.
right?
Yeah. Yes, that's correct. Thank you, Dan. And then, oh, yes, Kimberly, go ahead.
Yeah, just real quickly, I made this point last time, but just want to state again that wherever you're referring to protests and contested case hearings in these rules, you're only referring to section 2, the new law and subsection 2, but ORS 183 and OAR 137 still apply. So again, if we can fix that in the Division 2 to make clear that Division 2 incorporates that stuff, that's fine. But just wanted to note it today because we find this sprinkling throughout, including in this section under 5. So
yeah, thank you, Kimberly. Okay, so then we're moving to 2300 changes in character of use on page 17. That's just rule updates and clarity. So we're including references to the divisions for allocation of conserved water and Division 77 in-stream transfers and leases, because those are also subject to those Division 380 rules. Okay, so we're going to 2330, substitution of supplemental groundwater right for primary surface water right. That starts on page 18. And so we've got language in there about, I'm gonna go to that page myself, like I said, 18. And so look at sub 8 there. So we're providing greater transparency around our existing policy and practice, where we don't allow certain transfers to occur prior to the termination of a substitution. So if we authorize a substitution of a supplemental groundwater right for a primary surface water right, folks then can't come in and do a transfer on that without terminating the substitution first and applying and receiving approval for a new transfer application. Looks like we've got a couple questions from the group. So Leah, please go ahead.
Yeah, on 2330 sub 2, you've added to, so I know what enlargement is, but what is expansion? That does not seem to be defined anywhere, and I'm not clear on why that's being added.
We decided to modify section 2 so it exactly mirrors the statutory language. So we've taken out where it references supplemental ground and primary surface, so we removed that. And the statute for this says enlargement or expansion.
And how are we meant to understand that? Is that defined anywhere that I could look at?
It's not. It's not. So
It means same being. Then it seems like you have to clarify that in the definition of enlargement.
So we can take a look at
Yeah.
that, but this is one of those cases where we're trying to make sure that our language is consistent with statute, and the changes are to make it exactly with statute.
yeah.
Okay,
But-
thanks.
But if that makes it confusing, that doesn't help. I mean, because every word has a synonym, so we're not using synonyms for every single term that we have, or, you know.
Yeah, we can take a look at that.
Yeah. For this section or something.
Yeah, maybe we can look at that. Thank you, Leah. Greg.
Yeah, hi. Okay, so my comment is on section sub 8. And I have some real concerns about this, and I guess I'd just like to know, you know, what's this based on? You know, is this in statute? And before I get, I guess, the answer to that, I'd just like to point out, I've got a situation just like this where I've got a client who has been using a substituted groundwater right for years, and their well has become less efficient because of age, and so they would like to do a transfer to add another well, so they get a little bit, you know, get their efficiency back up in their system. And because of this rule here, I mean, you know, the question came up, and I asked the question from the department, and you know, the answer I got at first was kind of like, oh, gee, we don't know. And then I went around and around and around, and the response I finally got was basically what's in subsection 8 here. But what this means is for that client, in order for them to be able to, you know, drill another well for that substituted groundwater right, they've got to revert it. Then they've got to apply for the transfer to that for their, what then it becomes their supplemental groundwater right, and then they've got to reapply, or then they got to perfect that transfer, and then they've got to reapply for the substitution. And that whole process, you know, it's going to take probably 5 years at the rate things are going at the department. That process is going to take them 5 years. And during that 5-year period, they are not able to use that groundwater source. They've got to go back to their original surface water source. And you know, you got to think, well, there must have been good reasons for them to, you know, do the substitution in the first place. So that's a real burden for them to have to do all that. And to me, it just kind of like, I don't know if this makes sense. And maybe it's in statute or something. I don't know. But that's the question, I guess. Is this, where does this come from? Is this in statute? And if not, what is the justification for it?
Thanks, Greg. Yeah, we looked at the statute and it's 540, ORS 540.524. And it says you cannot change the place of use, character of use, point of diversion, or point of appropriation as part of the substitution. And so we believe that means that we can't approve those changes if a substitution is in place. So we have to terminate that in order to make those changes.
Okay, what was that statute again, please?
It's 540.524.
And it's
Okay.
subsection 1.
All right. Well, maybe that answers my question. Thank you.
Thanks, Greg. Kimberly.
Yeah, I just wanted to point out that, so in the statute in 540.524 sub 2, it does talk about an injury and evaluation. I know it's sort of, it's less, it's not written as clearly as it could be, but clearly injury is contemplated. So I guess the request is that you add that into the rule to make that clear.
Kimberly, would you do me a favor and repeat that statute?
Yeah, so it's the statute you just mentioned. So it's 540.524. But then when you look at subsection 2, it talks about the information needed to assist with the injury evaluation. So clearly they're anticipating that there is a injury evaluation.
Okay. Kimberly, in section 3 here in the draft rules,
Oh, did I miss that?
well, we do talk about we may request additional information if necessary to assist with the injury and enlargement evaluation. Were you wanting some?
Well, I guess I think it's basically that under 2, it's saying it can't be made if there's enlargement or expansion. But if injury is part of the statute, I would say it can't be made unless there's enlargement, expansion, or injury. Otherwise, it really just makes no sense that there's that provision in statute from our perspective.
Thank you. James.
Thanks. I had a similar comment to Leah about the word expansion, but think it might be able to provide some more information. The rule division for enlargement uses the word expansion. So if you go up to 0, 100, and then the definition of enlargement, it says enlargement means an expansion of a water right and includes, but it is not limited to, and then lists 4 different factors. So I see Lisa's point about trying to match the statutory language, but it does then have a sort of nonsensical result that in the rule that we're looking at, it would say leading to expansion of or expansion. So I would recommend not trying to match the statute here and deleting that use of expansion.
Thank you.
Thanks.
Christopher.
Yeah, so if you could scroll back to page 19 where Greg was talking about his concern. You know, Greg, we may have a workaround for you here. If we go back and look at the historical use, it says that if you're, well, just think of this scenario, your clients probably had a surface water right, they substituted for a groundwater right. Now that groundwater well is not functioning anymore. So getting back to the surface water right, maybe they just go and just drill another well and don't tell OWRD for 10 years that they did it, and then file for historic use for the change in a point of appropriation for that surface water, and just ignore the supplemental well that's declining. And 10 years later, you just file for the historic appropriation use. And so that'll be a workaround for this issue that Greg was building up. And I bring this up because I think it really punches a hole in this concept that the change in appropriation to reflect historical use has some serious problems with it. I mean, seriously, like somebody in the situation Greg was describing could simply just go drill another well, not tell you, wait 10 years, and then file for historical use change on this other well. And to say that that sort of thing won't happen is to ignore the number of misappropriations of water in the Harney Basin and other places. Thanks so much.
Christopher, great.
Yeah, Chris, I don't think that would work because, you know, in order to be able to do the historical change in point of appropriation, you still have to revert under these new rules. You'd still have to revert to substitution, you know, and then file for the transfer for the supplement. What then is the supplemental groundwater right? Then perfect it. Then file for the substitution again. I mean, it wouldn't change anything. And I mean, getting back to your, you know, your concerns about this historic point of appropriation change. I mean, if the groundwater section is going to be looking at those, I mean, yeah, you might meet the criteria for doing a historical point of appropriation, and that, you know, the well's been there for over 10 years, you've been using it, nobody's complained about it. But if the groundwater section looks at it and says, oh, well, this you know, this new old well location is closer to this stream, so now we're going to find that it will increase the interference to the stream, and if it's close enough to the stream, and if it's enough of a change closer to the stream, they might say that increased interference is significant, in which case then, you know, that's going to kill it right there. So I mean, it's almost like does it, you know, is there even any point in doing a historical point of diversion change or point of appropriation change? And in that case, when it's going to be evaluated by the groundwater section, you know, based on whether or not it's going to cause injury to, you know, basically injury to in-stream water rights when it comes down to it. So I mean, I just wanted to point that out. And I guess that's about all I had to say on that. Thanks.
Okay. Yeah, thank you both. And I want to turn to Carrie, and then we're gonna take a break.
Carrie from Frederick Tribes of Grand Ronde, I was just curious if the well drillers have fines that they can receive for drilling without notification.
Yes, I'm seeing that the looks are coming to me. So that's not through these rules, that's
Right.
through, our well construction rules, hence the looks in my direction. And so yes, there are, civil penalties if, you are not filing a start card. And that's what we call it, right? And, so there's a whole process associated with that for, the well drilling community, as well as for individuals. So, yes.
Okay, I was just trying to clarify how much of a concern that drilling a well and just to find a loophole in the system would it actually be likely to happen?
Well, you can have a legal well that doesn't require a water right, because we have exempt uses, right? And so, so that is you can still drill a well legally, right? And then there's this question around the use of it from a water right standpoint, right? So it can happen, and certainly when we find it, you know, we work to address it.
But if it were legally drilled for domestic use as the exemption, you can't just then be like, oh, I want to now use it for agriculture and move it, correct?
You would need to get either a water rate or you'd need to do a transfer. Yeah.
You have to do that, that happens.
Yeah.
For the latest legislation.
Okay, thanks, folks. So, Greg, please hold your thought. We'll come back to you first when we come back from break. So, we'll reconvene at 10:17. Okay, thanks, everybody.
So I can do it.
Yeah. Oh my God. Thank you. All right, folks, we're gonna get started again. And Greg, I promised to come back to you. I think we are still in, section 2330. And I just wanted to remind folks, we were only on page 19 out of, yeah, 68. So, after Greg's comment, we're gonna move on from this topic, but of course, if folks have other things to say about it, then they can submit written comments. Greg, go ahead.
Yeah, just wanted to mention that the well constructors here are only regulated according to well construction itself, not well. They want work with the clients, make sure they understand where the well is authorized, and to understand if there are any other well construction conditions in if it's for a permitted well, that kind of thing. But you know, ultimately, it's up to the owner to make sure that the driller is fully informed about all that, and not all owners do that, and that's, you know, and so unfortunately, that's just kind of one of the harsh realities that we face sometimes. And so we find ourselves sometimes trying to get people's butt out of the fire because of trouble that they got themselves into. I'm talking about the owners, not the drillers. So just a little point of clarification there. Thanks.
Thanks, Greg. I appreciate you sharing that perspective. That's helpful. Okay, so we're moving on to section 2340, specific to general industrial water use. So that starts on page 19. And you'll see that we have an addition under sub 3, sub D. But first I wanted to point you to sub 1. So in order to approve a change from specific to general industrial use, we need to know that the quantity of water to be used for general industrial use would not exceed the amount of water diverted from the original specific industrial use. So the language that we've added in section or sub 3, sub D, would clarify the information we need to make that determination. Do we have any questions on 2340? Leah, I see your hand.
Yeah, hi. I'm curious where this new 5-year average standard came from. I looked in the statute and that was not anywhere in there. So my understanding is, you know, anytime within the past 5 years, you know, that you've used the right beneficially, that would be evidence of, you know, the amount of water that was used under that water right. And I'm not clear on why there's suddenly a 5-year average that doesn't seem to apply to any other type of water right in terms of showing beneficial use.
Yeah, this is, so this is to make sure that we wouldn't be enlarging, right? By giving somebody the general industrial use, we wouldn't be enlarging from the specific industrial use by allowing somebody to use more than they've been using, but I'm turning it over to you for clarification.
Yeah, we didn't feel it was appropriate just to say what you used last year. So we're trying to, by doing a 5-year average, kind of take into account climate, variations of weather throughout the seasons to get at what somebody would have been using average.
Okay, I'm just not sure that that's consistent with the statute. I'm just thinking like, all right, if you used the full rate, if you happen to be using the full rate every year for 4 years, and then in the next year, for whatever reason, you know, there's some, I don't know, whatever problem you have, or there's not a market for that particular product, so you just don't use it for that year. Now your 5-year average, you're being cut down to like 80% of your water right. Why would that be okay?
Leah, are you suggesting, or do you have a suggestion for an alternate time frame that we'd be looking at?
I would just think 1 year, you know, within the past 5 years, that's, you know, you're not enlarging it. You're not going to use more than you did. But why is, I just don't understand the purpose of the average.
So you would be looking at the max
Within the 5 years.
The under-
In the
Yeah, within
last-
5 years, I guess. Yeah.
We'll take a look at that. Thank you.
Thank you.
Thanks, folks. So, the next one, 2430 on page 21, I'm gonna start the same things like, or 22-ish, because we've got some headers that are at the very bottom, but then the actual ruling comes on the next page. That's simply changed to correct grammar, so nothing really substantive to discuss there. Which brings us to section 3000, application for transfer. So, page 22, but I say 23-ish because the heading's on the very bottom of 22, but the real language starts on page 23. So, here we've got some straight implementation items from House Bill 3342 describing the application process steps, how we do our notices, electronic documentation. And then we've got some rule clarity and updates and processing efficiency and some policy items. There's also the land use piece, which I know we have heard from folks. I just wanted to point out that's the same language we've discussed previously under 310. So you'll see similar language here. But I wanted to call folks' attention to, in the rule summary, we've got sub C. And so let's look at on item sub 8. And so that's adding some application requirements specifically for changes in the point of diversion. And that information is to help us with an evaluation that occurs under section 5060 of the rules. That's fish screening and bypass devices. So we need some information from folks if they're changing the POD location, depending on if, you know, it's upstream or downstream, under 5060. Based on statute at 54525, when there's an application for a change in a POD, then we consult with ODFW to determine whether a fish screening or bypass device is necessary to prevent fish from leaving the body of water and entering the diversion. So to help with that existing evaluation, as it currently is in our rules, we have some additional application requirements here under sub 8. Okay, and then I'll go through the other changes before opening up for questions. So another one I wanted to mention, this one is under sub 12. And so here we need evidence that the water has been used beneficially. So that's basis measure limit of the water rate. Leave out of the word beneficially over the past 5 years in accordance with the terms and conditions of the right, or that the right is not subject to forfeiture under ORS 540-610. So there's pieces of evidence that folks submit to provide that evidence to us. We do have an evidence of use affidavit form. And so that's, you know, one of the items that they would fill out to provide that evidence. And then they can also submit additional information. So we've added some clarification to some of those requirements to make them more useful. Under sub A, we have a requirement already or a piece of information folks can provide, including receipts from sales of irrigated crops or for expenditures relating to use of water. But for example, somebody might have a 10,000 acre property and maybe they're looking to do, you know, a transfer of some smaller piece of that. Well, certainly they've probably expended money on or had sales of irrigated crops or expenditures related to use of water somewhere within that 10,000 acre property. But is it really applicable to the area that they're proposing to transfer? So we've added here copies of dated receipts so that it has, you know, we can tell what period of time those sales or expenditures occurred, and then information's on the receipt that ties the receipt to the authorized place of use that's under the water right. We also have added, just to show that there's additional options here under sub C, we already have dated aerial photographs of land or other photographs containing sufficient detail to establish the location and date of the photograph, but we've added dated satellite imagery. And then here under little b, so we've proposed a deletion because we believe it's duplicative. And so the language that we're proposing a strike is if the right has not been used during the past 5 years, documentation that the presumption of forfeiture would be rebutted under 540-610 sub 2. So Raquel, I'll turn it to you in case there's a nuance I'm missing here, but when we look under sub 12, we've got that language there. So I believe that that's why we were proposing a strike it under little b, is because that language already appears at the top of sub 12. So while you're looking at that, yep, that covers the major items that I would like to propose. Austin. Oh, sorry, we
That's
have
okay.
Jeff first.
Austin, go first.
Oh, okay, Jeff's letting you go first. Thanks, Jeff. Go ahead, Austin.
All right, thanks. Yeah, I did want to touch on a little b about the documentation that the presumption of forfeiture would be rebutted. So I know that statement is on the affidavit. Is that language going to be removed from the affidavit? I was figuring this was just removing this statement was just for redundancy for the rule, because the statute stated above under this section. But I'm just trying to ensure that this statement actually stays on the paperwork relating to the affidavit.
Yeah, thanks, Austin. I would imagine we would keep it on the evidence of use affidavit form. And it's just, like you said, since we've encompassed ORS 540-610 in section 12 here, we figured that covered lowercase b.
Okay, great. I do have an additional question. This is going to be under 12 sub A capital under capital A, kind of going back to the dated receipts and the updated language associated with that. So, I guess I understand that this covers large parcels, that may be expansive in nature. But what I'm hearing is that a receipt with situs address won't be sufficient to document the authorized place of use. And if it doesn't, what exactly would be accepted that defines the authorized place of use on a receipt?
Sometimes we will get receipts for power to dedicated meter or dedicated pumps, and it may show the location of the pump. And we don't get receipts very often. But if that's the only thing we get as supporting documentation to the evidence of use, it's really hard to tie it to the location. So that with other pieces of information may get us there, but I guess it's it could be it was for this type of seed. Here's a dated photograph showing that crop growing at this location, and we can we get aerial images that help us define that's the location that was at. So it's kind of, we take all those together and tie it to the location.
Okay, thank you.
Thanks, Austin. Leah. Oh, I'm sorry, Jeff. You were so patient. Go ahead.
No, it's okay. I mean, I want to flag that the same thing that Austin talked about. This was flagged by our legal counsel. It's a slippery slope when you're rejecting like power bills, because for pumping purposes, crop receipts, all that. I mean, when you're talking about some of these larger properties, I can get that there may be some question, but I think that it may be a step too far about outright rejection. And then, so I want to echo that. Then I have just back on page 23, is 8 sub A directly lifted from the bill? Because it seems like you guys are doing that already. Yeah, any water resources department staffer is gonna be able to figure out a POD location So I just called that out. And then we really, and then on sub B, you already are consulting with ODF and W, right, for fish. So I just call it out that when we get into economic impacts, that's adding yet another complexity for the applicant, to be able to prove that up. While the agencies are talking to one another, it shifts that burden, to the applicant.
Yeah, I believe these were, requests made by ODFW to help streamline their review.
Yeah, I don't care as much about them.
Okay, well, you know,
I said that out loud and I mean it.
Sure, thank you, but, you know, so we'll think about your point here, appreciate you sharing your perspective, so, you know, if the applicant already has, information about fish screens and passage to show that that issue has already been taken care of, that could actually make the review faster, right? We provide that information to ODFW, we show, look, we have evidence that ODFW has already given a fish screening certification. And so, you know, that should streamline it.
To the degree that we are getting to a point where these processes are becoming more efficient. Totally with it, notwithstanding my prior statement.
Sure.
But I just want to be conscious that, you know, let me give you an example. Let's say an application costs $3,000. And people go, oh, what's the big deal? You know, it's just $3,000. Well, to an Aggie, you always add 1 or 2 zeros. Right, so to them, it feels like $30,000 just because they're competing on this international market. So they're trying to do the right thing. So I only mention this because it is an important consideration when you're trying to do the right thing through a transfer, to look at what that cost structure could be while building in those efficiencies. So
Yeah,
I'll be quiet now.
thank you.
Yeah, I'm just looking at it. It seems like it's if they have the information scenario, submit it, because it'll make your application go faster. If you don't, it doesn't, you know, it doesn't mean your application is gonna get rejected, if that makes sense. So they could just not provide it and then it goes through the regular process, but I think it's intended to be a streamlining measure. If we don't have it written that way, I think that was the intention, right? Is if you've got it, provide it so we can move this along.
Again, that'd be a really cool thing for a checklist. Right? So as you're doing like your pre-work for a transfer application and, you know, fish screen applicability, check if you have this information, just recognizing that any information that you do not have readily, nor do you have it through a contract with an expert like Capillas, right? You know, just that recognition will also level set expectation on the how rapid your transfer request will be.
So checklist as part of the application for the applicant to go through.
I think it would be helpful. It also level sets what the expectation level is. You know, are you enlarging it? And if they check yes, that's probably bad. Just saying that out loud.
Yeah.
Yeah. Okay.
So it can certainly help to have information, the rules, making it really clear what we're gonna have on the application form. It doesn't limit us from what we can put on the application form. It just facilitates, but I think we will wanna take a look at this information and, you know, I think there are some opportunities we've got that language in there under sub A little b, provide any information if no, right? So I think that kind of language you may find helpful, Jeff, but you're looking at the other ones.
And I did warn you in the elevator write-up that this was an area of interest, the transfer day, so.
You told me today's Christmas.
It's Christmas.
And we're full of gifts. Because
Full
we're
of
trying to
gifts.
streamline. That was a good elevator ride.
Yes.
Okay, so I think we have Leah next. And thank you, Leah, for being patient.
No, of course. I had kind of the same question on sub A. I kind of get, you know, asking about the fish screens and passage because OWRD is not just gonna know that automatically, but the little a about whether it's upstream or downstream, it does seem like, all right, yeah, I could provide that, but you're definitely gonna know already, right, when you review that. And when we were looking at, I forget the number of the section now, but on new applications, we were proposing to remove the language that had us measure the distance between a POA and the nearest surface water, because you're already gonna do that. So this seems kind of like the same thing to me, like OWRD is already making this assessment or, you know, looking at this information. So it seems a little bit redundant. I mean, not impossible, but a little bit additional work. And then I had one tiny little comment on 12A C. Yeah, little a, big C. So if you're going to take out little b, then you don't need or at the end of that.
Oh, yep, you're right. Thank you.
Yeah,
So
that's it.
Lisa,
Thanks.
was the POD up or down, was that also a ODFW request? Does it tie into trying to, don't transfers have to go over to ODFW if they're
If it's a POD change.
a POD change,
Yeah.
right? And so this makes their process faster is essentially why it was being requested. Is
Yes.
that
Yeah.
true?
And, you know, and I guess I would also say, it helps make sure things are being interpreted the way the applicant is intending. It's just another double check for folks, but I think mainly it's aimed at, streamlining the process when we send it over to ODFW to get that review.
So some of this is about trying to make things efficient.
Okay, I need help on where we're at with order of questions.
One and then go back.
Okay, Glenn.
I don't have a preconceived answer to this, so I don't know. Is the language, that we're proposing here in 8 conflict with the existing ODFW stream program? So, I mean, did we go through and make sure that we're not conflicting with that?
I'm gonna make an assumption it doesn't, because ODFW suggested this language and we made, you know, little tweaks to what they suggested.
Yeah, and we ran it by ODFW.
Before we
were okay with
opt
it.
it in with our changes, yeah. Yeah, we don't wanna mess with that.
Yeah. Yeah.
Kimberly.
Yeah, to the extent we're talking about streamlining, or, you know, I think one of the big purposes of these 2 bills was streamlining. I would just say that we, one, support that language. I think getting as much information to the agency so it takes them less time is a good idea. Recall that in these bills, user interests, got additional time on their end for their application processes, but the agencies have a much tighter timeline. So I guess I would just say I support any attempt to streamline. So I support the language in 8. And then on the same subject, as far as streamlining, I would suggest that you put in this section something that clarifies that per application, there's one change per application. You know, if you look at the statute, everything is stated as a singular change, but we do see applications with multiple changes, which causes more work for the department, takes a lot more time. But the statute, you know, the new language doesn't distinguish between these complicated multi-change requests and a single request. So I think to streamline things and to better adhere with the statutes, I would ask that you clarify and rule that each application have a singular change. Sorry, that was sort of long-winded.
Thank you, Kimberly. Appreciate it. Jeremy.
Good morning, Jeremy, Central Oregon Land Watch. I was looking at sub 19. And I recognize this is similar language we've seen in other rules and is elsewhere in this rule set as well. But just want to make the comment that the comp plans they're an important guiding policy document, but they're often pretty vague. And it's often the case the local land use laws is really found in other regulations, usually like development code or local zoning code. And so we would suggest that it's important to include, in addition to the comp plan in this sentence, the language local land use regulations to clarify that those would apply as well. Thanks.
That's a great comment, Jeremy. So we will often see, I mean, for the reasons that you just described, we will often see the counties respond by citing to that particular part of their development code to show that it's either allowed outright or that they do meet those requirements. And so here what we've got is language that's the acknowledged comp plan. We're pulling that because of that statute at 197, 180, but you're absolutely right. They are referring to the development code most frequently in terms of the implementation part. So we'll take a look at that. Appreciate that. And Glenn, did you still have a
No, I'm sorry.
legacy hand? All right, thank you. Great.
Yes, hi, I've got a question actually for Kimberly. Based on one of the last comments, Kimberly, that you made, are you suggesting that if somebody is doing a change in place of use and that they need to do a change in point of appropriation to go along with that, that they have to submit 2 separate transfer applications?
I think if they're, I think if they're married, that's one thing, but unless the department has pushed back on these in recent years, I know in the past we have seen applications that have like multiple changes and multiple water rights as well. I'd be interested if the department has stopped that practice, that's one thing. But that's what the comment is based on, because again, those take a lot more time than a singular change, if that makes sense.
Yeah.
Well, I think it probably does take a lot more time when you're just looking at a single transfer application. But when you look at the amount of time it takes to process the multiple applications that you would have to if you were going to split all that up, plus the additional costs and everything to the applicant, I guess I don't think that there's any comparison. I think it's still much more efficient to include multiple water rights and multiple changes if they're, if it makes sense to do that, if they are kind of all related.
I think there's a sweet spot there, and Lisa's gonna note where the agency is at, because I think I think you're both right, so
Yeah.
there's a middle ground. Go for it, Lisa.
Thanks. Yeah, 690, 380, 3220 on page 30. We'll get to that, but that's where it identifies when you can have more than one water right involved in a single transfer application. So if somebody meets that criteria, then we would allow more than one right.
And Lisa, is that existing practice?
It's existing, yes.
So we have an existing practice around that. And the balancing act is if you get too many water rights on one application, then it gets too confusing, right? And it is harder to process. So there's a sweet spot there for us in terms of that balance. So it sounds like we'll get to that rule.
Mm-hmm. Yes, we will. Thank you. JR.
Yeah, I've never done this before. Can you guys hear me? I've never done a phone Zoom. Okay. So just 2 comments, and I think this does show that this needs some work. And getting back to the bill and the goal for process improvements. One, I agree with Craig on the singular change. As somebody that works in the critical groundwater areas where we have sub areas and allocations per sub area through the SAY, I think I disagree with Kimberly that having a singular change, 1, is consistent with the bill, and 2, there are certain instances where things need to be tied together. The other thing that I really will dig into and offer comments on, and I've made this comment again, but 1, just a philosophical statement. We keep talking about larger acreages, and in larger acreages, on average, we see and I think there's examples of this around the state that on average, we are well under our max rate and duty with technologies in some of these regions of Oregon. So I don't think that's as big of a problem as people are making it out to be in this conversation. The second, I would caution on anything related to like electrical records or aerial imagery. Again, we're getting into, I'm not an electrical engineer. I don't know if anybody at OWBRD is, but there has been significant back and forth with the department on power loads, VFDs, how that equates to ultimate, diversion, place of use, rate and duty. Very hard anymore with technology to have a model that works there. And then secondly, again, the aerial imagery side of this, again, with variable application, all the different technologies. These types of proof, I think we need to be careful on, and that's why I think the statute and rule were pretty clear back in the day, which was diversion and metered use, is that technologies change, and just having a picture that shows that something is green or dry does not necessarily match proof that that water was put to beneficial use and proof of use. So I think there's some comments we'll be making in writing, but this conversation is really concerning me that we're going backwards on process improvements and we're opening doors for a significant amount of back and forth between the on the ground users and the department that will take more time and potentially more litigation to address. So that's just my general comments for today.
Sure. Thank you, JR. Yeah, we look forward to your comments about that. And what can help us see hopefully pretty quickly that folks meet the requirements under sub 12. Right. Thanks, everybody. Appreciate that conversation. So actually, we're gonna get to separate application required for each water right section in a moment. That's the title. It's not my commentary. Next one before we get there is 3100 map requirements on page 27. That's our mapping standardization. So we were able to remove, you'll see strikeouts in there because the applicable requirements that we have, if we, realize that they are needed for our evaluation, those ones that are struck are in Division 305. And then you'll see some language left in there because those are not requirements that apply to every type of transaction under Division 305. Those are requirements that apply specifically for transfer application maps. So similar structure to what you've seen in other divisions. So moving to, and before we go ahead, Austin, you've got a comment on that section.
I do. This comment is related to 2 sub B.
Okay.
Yeah, so it goes on to saying that electronically generated stamp or seal is acceptable. I'm proposing that we include stamp, seal, and signature. Electronic signature is acceptable.
Okay, so that it's clear that it can all be in a digital format. Is that the intent?
Correct.
Okay, great, thank you. Now we're moving to 3220. It's entitled Separate Application Required for Each Water Right. And that is on page 30. So, really, actually, we weren't proposing anything massive here. You'll see that we're just trying to make it clear that, so for changes involving more than one landowner or water use subject to transfer, a separate application is required for each water use subject to transfer from each landowner involved, except under any of the following circumstances. So I believe this is so that it's not looking like you have to meet sub 1, sub 2, sub 3, and sub 4. We've got an or so that it's if any of those scenarios apply, making that a little clearer the way that it's structured. It didn't say and before, but it's just an attempt to make it clearer.
Right.
Okay, Leah.
Yes, I appreciate it not saying and that you have to meet all 4 because that could be tricky, but does that or mean that you now can only have 1 Because I've worked on some applications where it met 2 of those criteria. And I just don't want that to accidentally be excluded if that's not your intention.
It wouldn't be the intention. It has to meet at least one of these.
Yes, if any of them fall on it.
So maybe-
At least one, but it could be okay if it's more than one.
Oh, yeah, absolutely.
Okay.
Yeah.
Okay, cool. Thank you.
Okay. So then,
Katie,
oh,
the
yes,
hands
Jeff,
there.
go ahead.
So I don't know if I'm ahead of the game. I'm on page 33, would be sub F, 3 sub F.
Slightly, but you know, we're getting really
No,
close.
I can be patient.
We'll get there real
So
soon.
close.
You're excited. I like this. Okay, so, but before we get there, we've got, section 3400 waiver of fees. That starts on, the headers at the bottom of page 30, but the, rule language is at the beginning of 31, page 31. And so here, the changes are to make this, language about fees more consistent with what we have in statute. So the statute says, the director may waive all or part of a fee for a change to a water right permit under, and then it lists different circumstances. And so here we change the shall to may to match the statute. And then the language before was waive $100 or up to 50% of that. Or I'm sorry, it said $100 or 50% of the application fee, whichever is greater. At this point, I don't imagine we're gonna have any where the fee would only be $100. So we're looking at the, you know, that's not really a situation where $100 would really apply. So opening up for comments on that one. So now we're moving into, okay, the next one's really brief, 3410 waiver of mapping requirements. It's just a reflection of a statutory reference that changed based on legislation. So correcting the numbering there. And then we're moving into section 4000, initial review. And that starts on page 32.
Sorry, I just had a quick,
Yeah.
looking back at the one on the application fee, since you guys are gonna be charging, processing fees, do you need to clarify that that would be less processing fees? Or will that just be all bundled together as the application fee?
With, are you talking about the phased fee payment? or-
No, I was talking about when you go back to waiving up to 50% of the application fee. Does there need to be clarification there that the application fee and the processing fees are separate?
I get what you're saying.
Just as you look ahead to
Yeah.
charging that.
Okay.
Yeah, that's a good point, Lauren. We'll look at that.
Since April's not here to point that out, which she likes to.
Yeah.
Thank you.
Well, we appreciate those comments about, being forward looking and when we get to the point where we've got that technological setup. Okay, so, let's see, like we were heading into 4000 initial review, which starts on page 32. So Jeff, we're close to 33. So I mentioned at the beginning, there's phased application processing for transfers now based on House Bill 3342. I'll note some differences between that and what we talked about for the new water right application process. And this is not discretionary. This is just an informational item here, because this is just statutory implementation. But phased application processing for transfers, we collect all the fees up front because the way transfers are done, all the review basically takes place at the point of the initial review stage. There may be some additional information the applicant may choose to submit, but it's not like the water right application process under 310, where after the initial review, we may talk with the VFW, we may get the water master review. So there isn't phased fee payment for transfers as reflected in the statute. So we're consistent with that. And then also for the phased application processing, folks have 30 days to respond and provide us the needed information and tell us they want to move forward. But there's the option for them to request. We may be able to give them up to 60 days on top of that if we determine that they're undertaking reasonable efforts to provide the information in a timely manner. So that's strictly an implementation item. And then there's language, so you'll see sub C of the rule summary. There's language that for some reason under our existing rules, we've got rules about the draft preliminary determination, which, as I mentioned at the beginning, that's now being called an IR, that appeared under the PFO stage. So we think the rules for the initial review should be in the section titled initial review. So it looks like a lot of red line, but we're moving up language that was in the PFO section that really should be in the IR section. So that has been adjusted there to reflect that appropriate location. And then we've got, I flagged here too, add language to clarify requirements related to consent to injury transfer. So Kimberly, just, I'm gonna note there's, you know, a number, since you brought up a comment at the last meeting, there's a number of places where we've made adjustments based on moving the consent to injury process from where it currently is after PFO is issued to before that. So most things in our transaction processes would occur between IR and PFO, and then of course people can protest. So the consent to injury process has been moved up so that can occur earlier. And then also we don't run into that situation with a default to final order where someone has to then protest a PFO in order to then request to go through the consent to injury process. So I know we talked about that last time. Kimberly, it sounds like we might get comments from you on that, but I just want to let you know that appears here based on timing. So Jeff, and I'm going to close this door. But then Jeff, I want to get to your comments on page 33.
My time has finally come. Sub F, we believe this is too broad, just generally, but in the Raquel Rancière method of providing a solution.
Ooh,
Ooh.
Suck up moment, number one for me. We would say any other requirements set forth in ORS chapter 540 or OAR chapter 690, division 380. It just makes it cleaner for us and not, you know, that's our suggestion.
Thank you. Thank you. Yeah, we appreciate that.
Specific.
Specific is good. Thank you, Jeff. Kimberly.
Needs it.
No more comment, Kimberly. Okay. Raise your hand again if you
Sorry.
got something.
Sorry, I was chatting away with my mute on. To the I just wanted to respond since you mentioned that we had made comments on the consent to injury. We're still talking about it internally, and we'll get back to you with some written comments. But, you know, I think part of the larger concern, just so folks understand where we're coming from, is that if you look at the legislative history for consent to injury, it was very clear at that time that the intent was for consent, which is discretionary, by the way. Neither ODF&W or the department need to grant that consent. But the idea is for restoration projects. So if there was like a win-win project that would reduce flows in an in-stream water right reach, this would allow that to go forward. But we're seeing more and more that people are using it not for restoration projects. And so that's why we're looking at this section more closely.
Okay, thank you. I appreciate those comments. And then, of course, there'll be more CTI or consent to injury as we go through this, but I'll just kind of point out where that is. And then we don't need to discuss it until, you know, we've got more comments, but I can just flag where that is appearing in the rules. Okay, any more comments on this section before I move forward? Okay. So we've got section 4005, which is request for comments on page 35, and that's House Bill 3342 implementation with respect to phased application processing. So that's strictly an implementation item. The next one, oh, yes.
On page 36.
Yeah.
My same comment.
Oh.
We think it's too broad.
Which part?
Oh, lowercase
G,
oh, G,
G,
sorry. This one.
page 36, to sub reform.
Okay. Great, thank you. Okay, so we're just about to head into that section. Let's go there. So 4010, which is proposed final order, starting on page 35. And so, Raquel, I'm going to turn it to you in a moment to talk about the sub D part of the rule summary, which is modified provisions related to forfeiture. But before we get there, this is implementing House Bill 3342 with respect to electronic notification and when newspaper notice is required. And we also have some rule consistency elements that we updated.
We're also incorporating preparation of draft remaining right certificates at the same time as PFO, in case the PFO is not protested, then it all becomes final.
Yes. Thank you.
Yeah.
Because we do want to make sure the PFO contains everything it needs to, in case it becomes the final order.
Yeah.
So, little d in our rule summary modified provisions related to forfeiture. Our existing rules say the right has been used over the past 5 years according to the terms and conditions of the right, and the right is not subject to forfeiture under ORS 54610. It also says the water user is ready, willing, and able to use the full amount of water allowed under the right. The draft rules would remove some of that language so that we're left with the right is not subject to forfeiture under ORS 54610.
Yeah, so this is all, the rule currently is a bit odd. Because it is saying that we'd make, these are all components of forfeiture. So like, why not just get to the point, which is that the water rate's not subject to forfeiture as opposed to having these other components here. So that's why the change is there.
Really?
Kimberly, are you muted?
Yeah, sorry about that. So the statute actually, the governing statute, longstanding statute, this isn't in the new statute, actually has an and, so the right has been used over the past 5 years according to the terms and conditions of the water right, and it's not subject to forfeiture. And I think the terms and conditions is a bit more specific than the forfeiture. I'll double check, but I think given the statute has both, we would suggest you keep the remaining language and actually parse them out into 2 different sections so it's not confusing to people, if that makes sense. In other words, I think it was the intent was both, not just that it's not subject to forfeiture.
So Kimberly, is your suggestion, so the existing rules say the right has been used over the past 5 years according to the terms and conditions of the right. And
yeah,
the right is not subject to forfeiture. And so your suggestion is to consider keeping that language in there, but kind of break it out to where it's 2 separate items.
correct.
Thank you.
Thanks.
And then there's also language changes in there. You'll see strikeouts, which is just moved language. As I said before, there's language that applies to the IR phase. The under our existing rules is under the PFO phase of the rules. And so we moved that part up. Okay, then moving to 4010, notice of proposed final order starting on page 37. So we have some rule updates and clarity. We also have House Bill 3342 and 3544 implementation, including document terminology, when we provide notice, when newspaper notice is required, and other elements of 3544 standardizing request for party status. So that's an implementation item.
These are all just directly lifted from the legislation, right?
Yes, yes. Yeah, there's also, you know, we corrected references to other rules. So sometimes we need to make an updated reference in there.
We talked about the draft remaining rights certificates along with the PFO and notice.
Yeah, and that goes along with the thinking about if something were to default to final order, we need to have the draft remaining certificates in there. Kimberly, is that a legacy hand or do you have a comment on this one?
I actually I was still commenting on the last section, just to flag, you know, Jeff, I know you offered your suggestion that cites 540 and then 690, 380, and we had actually we had some language actually that maybe conflicts with that, which is that it also needs to adhere to applicable law. And so I just wanted to flag that for the department to consider. And then Jeff, I'm happy to chat with you offline if you want. Because we have seen instances where people are applying for transfers and they can't even apply for transfers, and it's not having to do with the use authorized. It's a different question. So just wanted to flag for WRT.
Happy to talk to you either through me or through Marika.
Great, thank you. Okay. So then we're now in 4030 protests and hearings. Page 39 has the title, but the rules start on page 40. And so here we have the House bill implementation. Real brief, that's House Bill 3544. Protests of PFOs and contested case hearings are governed by the House Bill 3544 in Division 2. Kimberly, I recall your comment earlier, thinking maybe, you think that may not be fully inclusive, so we'll look at that. And then also just noting the default to final order process. So this is strictly an implementation item. Okay, moving to 4200 hearings. So we have a few things going on here. One is more of the House Bill 3544 implementation. Describing contested case hearing proceedings. And then hold on, Jeff, is this on the last section or the one I'm currently on? So I want to get through my
The one that you're currently on.
Okay, I'll get through my summary
Yep,
and then
okay.
I'll go comment. Thank you.
Mine's on the last section, just so you know.
We're still on which one, Kimberly?
On the protests, sorry, I'm on the 4030.
Okay, okay.
Just really quickly, in addition to the point which you highlighted, my earlier comment, also to the extent this, and it might fold into the earlier comment, but like, for instance, here you have removed the standing statement, but there's no mention of petition for party status. And so if that folds into the general description, that's fine. But that also is something we're seeing throughout, is that the standing statement is being removed, but the words party status are not being added. So just flagging.
Okay, we'll take a look at that. Thank you. And then Jeff, is your comment, your comment's on the section I was just at, so
Yes,
I'll come
ma'am.
back to you after I finish going through that summary. So Greg, is your comment on 4030?
No, 4200.
Okay, thank you. I'll get back to you after I finish the summary and then talk with Jeff, and then we'll go to you, Greg. Okay, great. So back to the hearing section. So we talked about this last time, I believe. Besides the House Bill 3544 changes in rule and procedural clarity, something that we highlighted towards the end of last week's meeting is our process proposed here for consolidating the processes to resolve assertions of forfeiture with other protest issues. And I know we had a detailed discussion about that under Division 17. Just letting you all know, we talked about that and we'll continue to evaluate any comments we receive on that. So Jeff, going to you first.
This has been a consistency thing for me
Sure.
throughout this, that 15 days seems fast, even though we're trying to race through this. You know, we keep on suggesting that you consider 30 days. I mean, hopefully we get it done faster than that, but it just, from our folks' practical experience, when they do these, 15 days seems real quick.
Is that under sub 3, the consent to injury?
Yes. Yeah, 3, right there in the middle.
Okay, great. We'll take a look at that. Thank you. And yeah, that's a good flag. Kimberly, another consent to injury item. We did talk about this last week, but I said I would point out where that appears. Kimberly, did you have a comment? I see your hand was up first on 4200.
Sorry, that was a legacy hand. And again, we're still thinking through the consent to injury, so I'll respond to Jeff's suggestion later.
Great, thank you, appreciate it. Greg, go ahead.
Yeah, my comment is on subsection 2. You know, and I think I raised this issue before, but I'm really troubled, I guess, by this rule that allows anybody basically to just simply, by making an assertion that a water right is subject to forfeiture, that they can force an applicant into a contested case proceeding. You know, it seems like the other ways of, you know, going after forfeiture, either, you know, through the department or through the, you know, third-party submittal of affidavits, that there's a kind of a vetting process to determine if, you know, if the assumption or assertion of forfeiture is valid. Whereas here, it seems like the water right holder is guilty before, you know, until proven innocent. And it's kind of lacks due process. And I'm just kind of wondering, you know, maybe it's because I just don't understand where it's coming from, you know, but I guess I just have some real concerns about that.
So Raquel, I believe we had a rigorous conversation. So Greg, your comments, I believe, sound pretty familiar to the discussion last week about Division 17.
Yeah, we talked about this last week, and so Greg, we have your comments as well as the rest of the group's comments on this. I think, so we'll be evaluating it. If you all have a better mechanism, I'd be certainly interested to see it. This is one of those areas where it just, it's complicated, right? And if we are in this process, remember, at some point, this is not under 54610, that's the discretion of the agency to proceed. Under this one, there's not that kind of discretion, is kind of what Jesse had noted at the prior meeting. So we'll continue to take a look at it, but if you all have some solutions there, certainly interested in hearing it. It's just right now, it continues to be a confusing mess when these things arise, and so we need to provide some clarity around it. So
great, thank you.
All right, thank you.
I appreciate it. Okay, so moving to section 5000, approval of transfers. That's on page 42. So we've got some House Bill 3544 implementation. For example, if no timely protests are filed, we have the process where the PFO becomes the final order by operation of law, unless withdrawn by the department in a certain time frame. But I do want to point people to, we've talked about the evaluation criteria that we have. So you see that appear under the initial review rules. We have the same language under the PFO rules, and then we have the same language under the final order rules, right? Keeping consistency in our evaluation. So the comments that you have on the IR and the PFO sections would also presumably be comments that you would have on the final order language for the evaluation criteria. So I'm gonna make a note of that, because changes we would make to those sets of evaluation criteria in the IR and PFO rules, if we do make any changes based on comments, that would also be something we'd wanna look at for the final order. Okay, Jeff, you got a question?
Well, yeah, under sub F, just flagging that it could be as simple as any other requirements in statute or rules are met, kind of language. Just that we tend to flag these as we come along, so whether or not it's a consistency thing that goes forward as we go forward, I just want to flag them, so.
Yeah. Great, thank you. And then, you know, same comments folks already made about, so here, sub 1, sub C, we had a discussion about that. And so, you know, the language around forfeiture, so we'll want to take a look at that language that we have under the IR and PFO and let it as comments, as well as what we've got under the final order approval criteria. Leah, go ahead.
Yeah, on sub 2, maybe this is just a grammatical thing, but so I understand the PFO becoming the FO automatically after the 33 days, but it makes it sound like the remaining rights certificates also become a final order. So I don't know if that should be like pulled out and, you know, they become, I don't know if there's a final certificate or they just become certificates that are not draft, but somehow not making it sound like a draft certificate becomes a final order.
Okay, thank you. We'll take a look at that.
I think we should just say shall become final on the date versus saying final order.
That makes sense to me. Thank you.
Thank you, Leah. Chris?
Yes, thank you. This comment may fall under the category of that shiny little thing that just keeps distracting me. But under 1C, the repeated use of existing and then continuing the use of the language that says the right is not subject to forfeiture under 540610. You know, as worded, that requires the right to be categorically immune from forfeiture, which just, I don't think really should be we shouldn't keep using that language. Maybe what it should say is the right is simply not under forfeiture proceedings. And that's all I've got for this. Thanks so much.
Yeah. Okay, moving on to 5030, approval of injurious transfers on page 43. That simply changes for clarity and grammar. And then, do you have one thing on that?
Just that it reflects statute.
Reflects what's in statute, yes. Thank you. And then, section 5040, affidavits of consent, that's on page 43. And so, we have House Bill 3342 implementation and a conforming change, so document terminology updates, and including reference to PFOs, or I'm sorry, proposed orders, that may be issued by an administrative law judge following a conducted case hearing. Does anyone have any comments on that one? So moving to 5050, that's consent to injury of in-stream water rights on page 44. So we've got some House Bill 3342, legislative implementation, but then the main element there is changes to the consent to injury process because, as I mentioned, we'd be moving that process up between the IR and PFO. So Kimberly's expressed, you know, we'll see comments from her on this, but I just want to highlight that is one of those sections that we've changed based on that. Okay, section 5060, fish screening and bypass devices on page 46. And so we reordered some of the existing language for clarity. So it looks like it's new, but it's not, it's moved. So we moved sub 4 up to sub 2 because we thought the ordering made a bit more sense. And then we updated a reference to a statute that has changed. Okay, section 5100, compatibility with acknowledged comprehensive plans. So folks, I know there's a lot of thoughts on this one. We expect some of those thoughts will be pretty similar. You know, this is one of those, areas in rules where it says, we don't know, therefore it's fine, and we don't think that that is, that meets our requirements. So that's similar to, what we've previously discussed. And so, Jeff, it looks like you have.
Yeah, I mean, we're, from the nursery standpoint, we're talking with, like our municipality friends about how to perfect our thinking on this. I mean,
Sure.
certainly, one of my deep dark secrets is that I'm a former chief of staff at Metro.
Okay.
So land use planning, unfortunately, has been baked into my brain.
Great.
But it is, there are nuances here, and so we owe you and we owe this group some perfected thinking about how we can navigate this space.
Yeah.
So I just raised that as a offer and apology.
Thank you. No, we really appreciate that. Okay, well, we expect more conversation about land use and more comments. We're in 6010, failure to complete a transfer as grounds for cancellation. That's on page 49. And so for approved character of use or place of use transfers, our rules already state that if the transfer is not completed, that part of the transferred water use, and I'll put that in quotes, is lost, right? That's what it says in the rules. Our draft rules explain the timeline past which we initiate the cancellation process and implement the House Bill 3544 requirements for how the protest process works. And how the default to final order process works. So there's a little bit of 3544 implementation, but also, you know, what we have added beyond implementation is explaining the timeline that we use to initiate the cancellation process. The draft rules also make clear that non-completion of a change in a POD or a point of diversion or point of appropriation does not forfeit the water right subject to transfer. So we have explicit language saying that. And the draft rules also describe the process through which the transfer holder or receiving landowner may request to revert back to the last authorized POD or POA prior to the transfer. So we have section 6030, proof of use, non-compliance, page 51. We're simply repealing language that is now obsolete. So that's a rule cleanup item. All right, we're moving into the permit amendment rules. So we've got Kimberly, did you have a comment on one of the previous items?
Yeah, sorry, just under 6020, which there's no proposed changes, but I just had a question. Is there in fact a statutory allowance for an extension on a transfer? I couldn't find that. I guess I'll just flag that.
We'll check that out.
Okay.
So we're moving into the permit amendments, parts of the rules, and so calling out section 7000, which starts on page 54, and then taking us through 7300. And so I'll give a quick overview here before turning it over to our expert. So we've got statutes that apply to the permit amendment process. That's in 537 to 1174, but we don't currently have, maybe I got a little far down the weeds, 537 to 11. We don't currently have rules for permit amendments, and so we're adding rules to help folks understand how we have been processing permit amendments. So these rules are generally fashioned after how we do regular transfers, but we have fewer steps in the process. So it would go, they do go already direct to final order. So we didn't add process steps here to have an IR or a PFO stage. Now I'm gonna jump to 7-200 and provide a bit more information before I turn it over to Lisa. And so, something that I thought might be of interest to this group is language we've added to describe our policy and past practice. And we also then added a specific timeline. And that part, you know, is a little bit more nuanced maybe than what we've had before, to be really specific about this timing. But within 120 days of a permit expiring, the rule language would allow us the option to say it doesn't qualify for a permit amendment process. Because we may not have time to complete our evaluation before the completion date on the permit expires. So we can't issue approval orders on permit amendments for permits that have expired. You can't extend something that's already, or you can't amend something that's already expired. So they may, in that case, have to apply for an extension of time instead if the permit qualifies for one. And so I mentioned if the permit qualifies for one because, you know, then that gets to Division 315 and what's allowable. So I'm gonna go over to you.
Do you wanna?
No, we're gonna go through the explanation first. Thank you.
Yeah, so, let's see, looking at 7,000, this is just talking about the allowable types of permit amendments that those are called out in statute 537-11. And any questions on those?
Yeah, you don't have to go through all of them, but if there's
Okay.
anything that you thought really stood out, because I pulled out the one I thought, you know.
Yeah, yeah, so 7,300 is where we're calling out, these are the criteria that need to be met in order for us to approve the permit amendment. The timeline about discretion to not accept a permit amendment if it's going to expire in less than 120 days. That depends on what type of change is proposed. So if it's simply a place of use change, we likely can get through the review evaluation process in time, no problem. But it's the ones where it's point of appropriation change, groundwater review just tend to take longer. And so those are the ones that are sticking out in our mind, as we may not be able to make it through the process in time. Let's see. Also calling out in the application requirements on page 56, this is in 690-380-7100. We're noting that the applicant needs to be the record holder appearing on the water right permit or someone to whom the right has been assigned. So the assignment and permit amendment can come in at the same time. If the permit is for Joe Smith and the applicant is Charlie Brown, we just need to reconcile that. Let's see. And I guess I would also note that this, for the most part, has been our practice with permit amendments. We've only had statutory guidance up to this point, and so we've generally followed the transfer process, but of course, keeping in line with the statutory requirements there. I think that's what I would point out. For folks.
Thank you so much. I appreciate that, Lisa. Okay, great. Please go ahead.
Yeah, I gotta apologize up front here. Something sort of struck me as we were discussing transfers here, so I'm kind of going backwards here, but real briefly, that we were talking about the amount of time allowed to perfect a transfer. And typically that's 1 year, and then you can get it extended if you want to try to do that. But there's also an option right now that we have, where, you know, if you're in the proposed final order stage, I believe, and if you think you need a little more than a year to complete the change, you can actually request a little more time and get that right now. And I'm just kind of wondering if these new rules, and now with these new rules, is that going away, or is that option still going to be available?
The plan was to maintain that flexibility, so what we typically, we will typically ask for additional information to support the request, and we like to get it as early as possible, so with the application is great. At the IR is where we would put our proposed completion date, and then we typically get response back from applicants following the IR. So that would be our preferred place for that.
Okay, that sounds
But
great.
but we do plan in the draft rules to maintain that.
Great, thank you. And then I only had one other comment on the permit amendment rules here. Initially, we're talking about this 120 days, kind of time frame. And I think that's great. I mean, in as far as 120 days until the completion date of that permit. Because up until now, there really hasn't, I don't think, been anything written as far as that, that time frame. And we're looking at it and it's like, oh wow, we want to do a permit amendment, but our completion date is maybe 6 months away, or maybe even a year away, but we don't know if that's even enough time to get a permit amendment done. And so in my mind, actually setting that time, 120 days, that's, to me, that seems pretty fair and reasonable.
Thank you so much, Greg. Appreciate it. Chris.
Yes, thank you. On page 55, small point here, but under 7020 1A, it says in the middle there, except that a water right permit need not be a water use subject to transfer. I'm just curious if that's necessary. Aren't permits actually not water uses subject to transfer, and except for maybe like right before it's about to get issued a water right certificate. So if you could just clarify that, that'd be great.
I think what I was just trying to make clear is, even though it's in the transfer rules, just trying to make it clear that permits are different. They don't need to be a water use subject to transfer. So
they're non-perfected, non-certificated.
Yeah. So you're thinking that's unnecessary?
Yeah, I just thought it just creates this impression, well, where are those permits that would be subject to transfer? And then my question in that regard was, are permits that have made a request for certification, like my certified water right examiner is coming tomorrow, they're going to like prove beneficial use. Is there a point where like, is there any instance where there's a permit that could be a water use would be subject to transfer? And that's what was going on with me, is like, well, where would there be an option? Thanks.
Yeah, thanks, Chris. The only ones would be where we got a permit, where they've submitted a claim of beneficial use and the department has determined, proof, on that, so satisfactory proof, and then an order is issued. So that can be on a permit or a transferred right, but the proper proof part of that is it's gotta have the order from the director saying that it's, determined satisfactory proof.
And then it's water use subject to
Then it's
transfer
a-
anyways,
yeah,
right?
Yep,
So,
then it's a water use subject to transfer.
Lisa, a question for you here on this. Is this failure to complete, does this apply to permit amendments? I think maybe that, Chris, is what you're getting at here, is that, is there a need to include it if this section isn't about permit amendments, which would be the separate process that does apply to permits that are also not water uses subject to transfer?
That's right, the 60-10 failure to complete does not apply to permanent amendments. Because they've got, they kind of fall under the permit and certification. And so if they fail to prove up on that, then they just wouldn't get the certificate.
I'm not seeing where the permit language is now. Now I'm now I've confused myself. How's that? Okay.
Do we want that to be an item we follow up on?
Okay, I see. So. Yeah, never mind.
Yeah, 60-10 talks about water use subject to transfer.
Chris, what was where was the exact language that you were pointing to that said it seemed unnecessary?
You know, in the middle of 1A right there. Yeah, I just was asking about, you know, whether or not that really made a lot of sense. And it's a legitimate question I have is, does it? I don't actually know the answer.
1A on 7,000?
7020, it's the one that's been highlighted.
Got it, okay.
Because there's gonna be permits that folks want to do an amendment on that are non-perfected, non-certificated rights, rights that are not subject to transfer. So we're, I think, probably here trying to make it clear that you don't have to have, the permit you're trying to amend doesn't have to be a water use subject to transfer. It's broader than that.
Right.
Yeah, okay.
I've made a note and I'll look at that one.
Okay, great. Thank you, Chris. Kimberly.
Yeah, in looking at section 710, under 1C, we would ask that you strike or additional point of diversion. The statute does not allow for adding points of diversion. It's very specific to changes in point of diversion. So, and I appreciate the department has done some of this in the past, but our position is that the law does not allow it. So I don't think putting it in rule is the way to address any disagreements on that.
Let's take a look at that. Thank you. Leah.
Hi, yeah, my question on the permit amendments is more, I know on some of the other sections, we talked about whether things could be done electronically versus everything has to be on paper. And this one on 7100 sub 1 does not ask for the email address. So I was wondering if that was because you can't communicate electronically on this type of transaction. And in 7300, it doesn't say, well, that's the one about the final order. And basically it just says that the permit amendment application will be approved if it meets these criteria, but it doesn't actually say that OWRD will issue a final order. Whether electronically or mailed to the applicant or something. So I was just,
And Lee,
that's, yeah.
are you in the second comment? I caught the first one. The second comment was that about 7,200?
7,300 here, yeah.
Okay, okay.
It describes this criteria, but then it never actually comes out and says, and then we'll issue a final order and we'll mail it to you, or we'll transmit it electronically, or like, how do you get that?
Okay.
Yeah, I want to say that these were kind of fashioned after the temporary transfer rules, and they're not as specific as the permanent processes. That may be why the difference, but no email address, that's an oversight, so thank you.
Okay.
And Leah, I think part of what's going on here with, you know, final orders and not saying if it's electronic or not, we're required to send out final orders in paper copy.
Okay.
So I believe that's under the Administrative Procedures Act, but that is one where we just don't have the discretion there to move to electronic.
Okay, yeah, no, that makes sense. It just doesn't say that one will be issued at all. It just says it'll be approved if it meets the criteria. So,
okay, we'll take a look at that.
Thanks.
Katie, I'll just note, I finally have figured out what Chris was saying. Sorry, Chris, I was not totally tracking there, on your 7021A comment. And, after looking at the language, I believe it is correct as stated. And necessary to say that, so.
Thank you, Raquel. Appreciate that. Okay, so we're really close to getting done, but I do want to do a time check with Laura, Mindy, to see if we've got anyone requesting public comment. I know we have wrap up, so see how much time I have left to keep going.
Anybody online is a member of the public that would like to make comments, if you could raise your hand, just so we can get a count. Anybody's in the chat? We got one. Okay, Ted, so we got one.
So should I stop at,
I mean, I won't need much time. So.
okay, 11:52? All right. Thanks for letting us know that you want to comment, Ted. We'll make sure we got time for you. Okay, then we've got section 8,000 temporary transfers at page 60. That's pretty straightforward. We're conforming the rules of statutory authority. So the statute doesn't provide the authority for temporary change in character of use of a right to store water. So we remove that because we don't have the authority to process that. 8,002 temporary transfers, applications, under, and then it cites the rules. And so that's one of those headers at the bottom of 60, page 60, rules are at page 61. And so here you'll see the similar language about need to make sure the change will not result in enlargement. We have reference to additional requirements for temporary transfers. And so that's just noting that the seasonal use rules and supplemental water right requirement rules apply to temporary transfers. So we're just making that clear by adding those references. And then we have language that a previously approved temporary transfer may be revoked if it is resulting in enlargement. And we've updated the statutes implemented by this rule. Christopher.
Yeah, just briefly under temporary transfers where you struck out 1B, was there ever a time when a character of use to store water, could be transferred? Like, I wasn't really sure character of use on any level could be transferred. And thanks so much.
Yeah, thanks, Chris. There's an allowance in the district transfer applications for, I believe it's the temporary district transfer. So somehow that got plugged into here, but on the regular temporary transfers, no, we've never been able to change use.
Yeah, Great question. Okay, so section 8003, renewal of a previously approved temporary transfer application. So we're looking at bottom of 61 and then starting into the following page. And so what we're doing here is we have rules allowing for the renewal not to exceed a period of 5 years of a previously approved temporary transfer. So the proposal, just to be clear, needs to be exactly the same as a previously approved transfer. We think this is fairly low risk because if it does happen to result in injury, we could revoke it. Any comments on this one? Then section 8003, renewal of a previously, wait, no, that's where I just was. All right, we're ahead, guys. 8004 temporary transfer applications on page 63. So we've got some rule clarity and updates. There's House Bill 3342 notice requirements that we built into this as some draft changes for implementation. So that brings us to our last one, 9,000 clarification of water rights. We've got some House Bill 3544 implementation, conform the rule with updates that were made to statute at 54560. And then here we've got, want to be clear that by striking some language in what is now sub 8, the first sentence there, we're proposing to delegate authority to the department to issue a final order after a contested case hearing. I'll get to you in a minute, Jeff. Thank you. Delegate authority to the department to issue a final order after a contested case hearing, even when exceptions to the ALJ's proposed order are timely filed. So, you know, the first sentence that we're proposing to strike is if no exceptions or objections to a proposed order are filed, the director shall issue a final order. So, one might then make assumptions about the inverse situation, right? If exceptions are filed. So what we're proposing here is that the department would be the one to issue a final order rather than the commission, even when exceptions are filed. Okay, Jeff, you had a comment.
Since it will be a blessing to you all that I'm not going to be here next week, I wanted to catch you doing something I thought that was really well done in print number 1. I just think it helps clarify the process under 9,000. So I just wanted to say good job.
Oh, thank you. Which part of 9,000 specifically?
About the proposed final order clarifying and defining the description. So we just wanted to catch you doing something.
I like that. I like being caught doing good things. So you mean that we're clarifying that it's a proposed final order?
Yeah,
or...
just, I mean, the whole decision kind of process, I thought was clarified by that one.
Great, thank you so much. I appreciate it, Jeff. Yeah. Okay, well, that got us through 380, which is amazing, everyone. Thank you so much for your input and your time. So ceding my remaining 2 minutes over to Mindy and Laura, I guess Laura for next steps, and then we move to public comment, I believe.
How about we do public comment? You know, get the PowerPoint going.
Ted, are you still there and ready to comment?
Yeah.
Great.
So my first comment is about the permit amendment section, specifically 690, 380, 7300. So there's the department lists a number of criteria that are going to be used to evaluate permit amendment applications, and most of them are consistent with the statute, but there are at least 2 that are provisions that are not called out in statute as being criteria that will be used to review permit amendments. One is item 1C in the rule, in the proposed rule, and the other is item 1H. They're not consistent with the statute. And then my other comment is about the 100 120 days that the department is proposing to add as sort of like this one bookend to say, well, you need to have permit amendments submitted by at least 120 days in advance of the completion date in order to provide adequate time for review, which is very reasonable. I think I'm going to echo what Greg said. That's a good thing to have there, but that's only establishing guardrails on one side of the process. I would like to see a guardrail added on the other that holds the department's feet to the fire for processing applications, specifically permit amendments, because unlike transfers, while it may be inconvenient for an applicant to wait multiple years for a transfer to be reviewed and approved, it doesn't necessarily put the water right in jeopardy. With permits, the applicant is held to the completion date. And I've had a couple occasions, I have one now, where the applicant submitted the application in 2001. It took the department over 2 years to do the groundwater review, and we didn't get the PIA. We didn't get any indication of where the department we're going to go with the amendment until 2004. So that's a 3-year process that this applicant has additional time left to their completion date, but there could be others where they don't have that luxury and they could be forced to go into the permit extension process just because of the inability for the permit amendment to be processed. So it would be nice to have a guardrail on the other end saying that if the department can't process a permit amendment in 2 years' time or 1 year's time, we got to come up with some kind of allowance of what could be taken, that the permit, like maybe the applicant is given just additional time without having to go through an extension, because it's not their fault that the permit amendment's not getting reviewed. And I'm not talking about permit amendments that get tied up in a protest or tied up in some kind of logistical issue. This is just one simply because it is not getting processed. And with the changes to the extension process, that could be a real jeopardy to a permit holder where they're trying to develop the usage. They can't get the permit amendment processed, and then they can't get an extension. And at least the applicant that I'm representing sort of feels like the department is just trying to run out their development clock. So that's—
Ted, thank you for that comment. Bryn, can you note this as a potential need for legislation? It kind of reminds me of that. While on transfers, the forfeiture clock is kind of told while the transfer's pending. And it seems like maybe there's something similar on the permit amendment side of the house, and given the changes, as you note, to extensions. So we're gonna add it to our list of things to think about, because I think we would need a legislative change for that. And there's probably a way to do that in a way that, you know, makes the process make sense. So thank you for flagging that. Did you have any other comments, Ted, or were you done?
No, that's it. That's it. Appreciate the time.
Great, thank you. Laura?
Yep, okay, so next steps, we've got our next 2 RAC meetings back to back next week. Wednesday, we got through 380, yay. We're gonna start on 382 and get into Division 77 in the AM, and then in the PM, continue with 77. Some possible follow-up depending on, you know, what we work through on earlier divisions that we've already discussed. If there's time allowing, we'll also try and get into some of the content in those statements that I mentioned earlier, the fiscal and economic statement, racial equity impacts, and the statement of need. We'd like input on Division 380 by November 5th. I did not put it on this slide. I mentioned at the beginning, we've got our Division 2 follow-up meeting on the 31st from 10 a.m. to noon, and that's virtual only as well. And then a reminder to complete that lunch survey from Mindy, and if you didn't get it or need some help with that, let me know and I can forward it to you or help you fill out the survey if needed. So, that's all I've got. I don't know if Katie or Raquel have anything.
So you all did a tremendous job here getting through 380. So, great comments today, helpful to us. We'll take a look at it. Just as a prompt for you all, 382, much of the changes in there are very similar to some of the changes in 380 or are nearing 380. So, that one should go even faster, I think. We'll try to be cognizant of those areas where you provide a comment and we will maybe not have had time to make adjustments there or evaluate the comments. And then we'll have 77. We will get that out to you no later than tomorrow. That one has a lot of changes in it. And part of those changes are coming back from the prior rulemaking that had a RAC and then had some hiccups and got put on hold. And then some of those changes are obviously from the legislation as well as other policy matters. So that one will be a bigger discussion, I suspect. And then we'll try to come back with some of those other changes, but just be thinking about that as you go through 382. A lot of that is already similar to 380. And some of the things that are different are because of the nature of those water rates, which are that they are registrations, right? And so they are not quite, they haven't been adjudicated yet. So there's some differences there. But for the most part, a lot of similarities. Thank you. Are we done? We're done.
Thanks, everybody.
Nice work, everyone.